Yes, Mr Scott.
Matt, please, Commissioner, I continue to appear with Ms Marsh this morning.
All right, and you're still appearing, Ms Hogan, do I?
Commissioner, there's a couple of changes during the course of today. I might just announce in
Sure,
respect of each
okay.
of those. For the continuing witness this morning, Mr Glover and I appear for the Commonwealth. The next witness will be me and Ms Nicholas, and then this afternoon will be Mr Glover and Ms Nicholas.
Okay, thanks. And I understand we've got Mr Guo, is that right? All right, thanks, Mr Guo. I assume you're not. Oh, well, anyway, I'll check at the end of this witness's evidence whether you have anything to ask, but I assume you're not really so concerned about the evidence.
No, that's
at
so.
the moment. All right, thanks. Yes, Mr Scott.
Could the transcript of yesterday's proceedings be brought up on the screen, please? And in particular, page 2739. Now, Ms Musolino, can you see that transcript on the screen there?
Yes.
And do you accept that that's the discussion on that page relates to the discussion we were having yesterday about that decision of the AAT?
Yes, I think I remember which one it was. Yeah.
Okay. You see just below line 15, my question, in effect, a conclusion of a Tier 1 AAT decision that a fundamental aspect of the Robodebt scheme was unlawful. Do you see that?
Yes.
And you recall that I was putting to you that was the effect of what that decision determined.
I think, I probably needed to clarify what I meant. I think I was accepting that the AAT1 decision had determined, I'm trying to remember the decision, but I think it had determined that you couldn't lawfully use averaging to establish a decision, a valid decision in the circumstances of that matter. So I don't think an AAT1 decision is capable of declaring an entire scheme unlawful. I think it was declaring that you couldn't apply averaged ATO data to determine a decision in that matter, but it was in relation to that matter that the decision related.
But the premise of the decision was that a debt could not lawfully be raised based on averaging.
That was the premise of the decision. It was applied in the facts of that matter, obviously, because it's a decision about a particular matter. So I don't know if I can add any more to that. It's an AAT1 decision based on the particular circumstances of a particular matter. It may be asserting that, I think if the assertion is you could never probatively make a debt decision based on averaged ATO data, well, that's an assertion, but it's actually the AAT1 decision is deciding about the facts of the particular matter.
But the assertion of the AAT was that a fundamental aspect of the Robodebt scheme was unlawful, wasn't it?
I don't know if that was the expression used. That decision talked about whether you could be sufficiently satisfied from averaged ATO data in order to make a decision regarding debt. It's quite a long decision. I don't know if those exact words are used or not, but my understanding of what I was answering there was it asserting that a fundamental aspect. So that fundamental aspect is that threshold question of whether you can rely on averaged ATO data to make a valid debt decision. That was asserting that you couldn't.
Yes.
But it was in the context of an AAT1 matter about a particular customer.
Right. But you accept that the question whether or not a decision could be lawfully made under the scheme using averaging was a question that was of fundamental importance to the Robodebt scheme.
It was a key design element. The key design element of the scheme was that you could rely on averaged ATO data as a valid basis to make a decision. So it's a key design factor of the scheme, yes.
And the conclusion reached in the AAT in that decision was that in respect of that fundamental aspect of the scheme, that couldn't be done.
That was the assertion in the decision, in the reasoning of the member, in the context of a matter involving a particular customer, which of course all AAT1 matters turn on the circumstances of the particular customer.
Commissioner, I've just noticed that the live transcript doesn't seem to be running on my screen.
It's going fine on my screen, but
But you accept that the conclusion of the AAT wasn't limited to the circumstances of that particular case.
Well, the AAT members' reasoning reflected what you've described, but it was a decision on a particular customer's circumstances, and the directions to the department related to the particular customer. So the reasoning reflected that view. The decision is actually related to the particular customer.
So was it your view, therefore, that the department was entitled to make decisions contrary to that reasoning?
The department didn't agree with the reasoning, so the department was entitled to implement the decision as directed. It didn't have to agree with the reasoning in order to implement the decision.
Notwithstanding the specific requirement in Section 8 of the Social Security Administration Act for the Secretary to have regard to the decisions of the AAT.
The department has to have regard to the decisions of the AAT. It doesn't have to agree with all the reasoning of a variety of members, and the reasoning will vary over different members. The way that the department has regard to the decisions of the AAT is to consider them, and then they have two options really. They can recommend an appeal to the Department of Social Services and seek instructions, or they can implement the decision. They're the only two options. So having regard means you consider the decisions, which we did. We considered the decisions against the criteria in the standing operational statements and the litigation principles. A reviewer looked at those decisions and reached a conclusion about whether an appeal should be recommended. If ultimately there was no appeal, then it had to be implemented.
And so in circumstances where there's a decision of the AAT that an aspect of the scheme, I'll rephrase that. In circumstances where there's clear, considered and detailed reasoning in a decision of the AAT that an aspect of the scheme is unlawful, it is open, in your view, to the department to, if it disagrees with that reasoning, act contrary to it.
The department's obligation is to either appeal or implement the directions from the AAT. So they're the two options. Different AAT1 members, there are a lot of AAT1 members, and they would have had different views and different reasoning around how they got to their decision about the outcome for the particular customer. So that's probably all I need to say there.
I think we've been over this before, but you are not really implementing, what you're implementing is the directions, you're not implementing the decision.
That's correct. We're implementing the directions from the AAT Commissioner.
Okay, so you are in effect disregarding the rationale of the decision.
Well, we don't need to agree with the reasoning.
Well, you don't, you can appeal.
Well, but we don't need to appeal in order to implement so how we're set up to consider AAT1 decisions is they're not necessarily consistently going to have the same reasoning in every AAT decision. Every AAT member may approach the reasoning in a different way. We are obliged to have regard, and we're obliged to implement whatever they direct, or else we appeal. But the fact that we don't agree with the reasoning doesn't mean we won't or can't implement the decision. If we can...
We've just discussed this. You can hardly call it implementing the decision if you disregard the reasoning.
Well, it's implementing the directions. Sorry, I should
Yes, that's
chosen
right.
my words.
So on your view of life, you could go on indefinitely with the AAT finding that you were breaching the law, really, and it wouldn't matter because you would just implement whatever directions were made and on you would go, in complete disregard of this constant indication that there was a problem with the way you were not complying with the Act.
Well,
But it doesn't have to be in every case. If you've got the AAT telling you in a number of cases that that's so, you felt free to ignore it?
Well, there were many other cases where the AAT was accepting or directing that we average. So there wasn't a unified view from all AAT members.
Well, all the more reason to get it sorted out, wasn't it?
Well, there were different views. There were different... As I said, the way we operated in this environment, it's meant to be a quick, efficient process for customers. We've got tight timeframes to respond to matters. The decisions were cutting both ways, so they weren't all going in one direction. We were following the operational statements that we had from the Department of Social Services. They basically required that we consider an appeal or we implement. And
didn't those operational statements require you to refer things to Social Security if there was a significant decision on the law or a question of policy or it was attracting significant media attention? Wasn't that in those directions?
There's a list of factors that we need to take into account.
Those are three of them, aren't they?
Yes, but there are others related to the impact.
Ticked all of those boxes, didn't they?
Well, there were others that it didn't tick, so it wouldn't have been for the interests of the customer in that matter to take them through an AAT2. And can I just reinforce what I said yesterday? Appealing one of these matters to the AAT2 may not have resolved anything because the AAT2 would have done their own merits review. They, in all likelihood, would have come to the exact same directions that the AAT1 would have come to.
Give you the chance to get it sorted out in the federal court.
But the AAT2 decision could have used completely different reasoning. They didn't have to... AAT2 members didn't have to adopt the reasoning of the AAT1. They just had to look at the merits of the matter.
Ms Musolino, frankly, it seems to me you let this system run, getting decisions from the AAT that told you there was a fundamental problem with its legality on a kind of, oh, well, case by case, it doesn't really matter, we'll confine it to that case's rationale.
We operated within the framework that had been set down for how DHS provided these services to the Department of Social Services.
You were Chief Counsel, you were supposed to keep an eye on all this, weren't you? And you seem to have been oblivious to what was going on in the AAT. Well, either you were oblivious or you knew.
Well, if I can just explain, as Chief Counsel, my role is to actually manage the legal division. It's a huge legal division. I had systems in place for this, for supervision to occur, for monitoring to occur. Each and every one of those decisions was looked at by a lawyer, reviewed, and a recommendation was made. I couldn't do the work of every lawyer in the division, But I was confident that there were systems in place for those decisions
What was the
to be
system for
read.
identifying a recurring theme?
Well, that's what we talked about yesterday. I think that was one of the deficiencies, and I accept that. I don't think there was a mechanism, a clear mechanism to capture, because the matters were being dealt with transactionally for the individual customer, one at a time. We had a lot of different reviewers, lots of different AAT members, so there's not a single person reading every decision and absorbing it. As I said yesterday, one of my reflections is there didn't seem to be a strong mechanism for capturing this kind of commentary and feeding it back to the Department of Social Services as the policy agency, who could then have done something.
Really good standards that said if there's a matter of law, a matter of policy, or media controversy, that's a basis for referring it to Social Security. Should have worked a treat, shouldn't it, in this situation?
Well, except that, again, I take you back to the volume of matters we're dealing with and the variety of different members and the different approaches that they're all taking. And the matters are merits review, so people are looking at very unique, circumstances for each customer. So I think we could have done better, but this is not, a matter where we have 10 cases a year. There's hundreds of thousands of decisions, 13,000 AAT.
Sounds very much as if you're saying, well, it's happening to a lot of people, so you can't expect us to do anything about it.
No, I'm not saying that at all. I believe we had a system in place to deal with the decisions as expeditiously as possible for the recipient to have the matter resolved as quickly as possible. What I think I reflect was missing was a stronger feedback loop on decisions that we weren't going to recommend an appeal for the reasons that we discussed yesterday, because of the impact on the recipient. That wasn't necessarily going to change the outcome, but to capture the feedback.
What about the impact on all the other recipients when you weren't getting this question of law, which had been clearly identified, sorted out?
Well, we considered it was sorted out. We considered that...
In what possible sense? You had decisions which said the legislation doesn't permit you to do this, and you had done nothing to get it sorted out.
Well,
Nothing, not even gotten advice.
Well, as I said, and I don't know if you want me to take you through it again, Commissioner, we relied on the advice that was obtained in 2017, the assurances that had been taken into account in the 2015 Cabinet decision. We had the Ombudsman review in 2017. There was continued scrutiny by the Ombudsman. We had AAT 1 decisions and AAT 2 decisions that had approved or endorsed averaging. So
The AA2 decision that had approved or endorsed averaging, I don't think I've seen it. What is it?
I probably could come back to you. Halls and is one matter that comes to mind. I can't recall if that was an AAT1 or an AAT2. I could probably find out.
We can go to those if you want, Ms Musolino.
Yeah, but I do recall there were decisions cutting both ways. So there wasn't...
Well, as I said to you before, that's all the more reason to get clarification, isn't it?
In hindsight, we needed a better way to capture this.
Thank you. I've got nothing more to ask.
Commissioner. You had been Acting General Counsel in 2014, Ms Musolino, correct?
Yes.
You'd achieved the permanent designation of that role in early 2015.
Yes.
This was more than 2 years after that, correct?
2017 was 2 years after that, yes.
So we're talking about the decision given in March 2017.
Yes.
And you had not, by that stage, put systems in place for an appropriate feedback loop regarding reasoning of the AAT as to the lawfulness of the department's actions.
Well, I believed we had a system in place, which I described yesterday. I believed we had a system in place that was going to be effective and efficient. Decisions would be dealt with and read expeditiously. They would be implemented in a timely way. As I said, every decision was being read by a lawyer and reviewed to make a recommendation. At the time, I considered that the system that we had was sufficient to meet our obligations. I know there was communication between our department and the Department of Social Services from time to time about appeal matters, and it's not that we never appealed or never recommended any appeals, because certainly I can see there were secretary appeals on a variety of matters into the AAT too. So I considered that the framework we had was sufficient to meet our obligations. With the benefit of hindsight, I think we could have had a stronger feedback loop. That would have been a good enhancement to have. But at the time, I believed that we had a good framework, and it was a good, solid framework.
Do you recall, Ms Musolino, yesterday when I asked you about paragraph 23 of your statement regarding the circumstances in which matters might be escalated to you? Do you recall the question?
Paragraph 23 of my statement. Which statement, sorry?
First statement. Perhaps, actually, if we could get it back up on the screen, the transcript. Page 2622. Now, can you see on that page on that screen, Ms Musolino?
No.
You can't see that page?
I can see the transcript. Is that what you were directing me to, the transcript?
Directing to
Sorry,
the transcript, I'm sorry.
Yep.
And you can see, I refer you just above line 15 to that paragraph of your statement in relation to which matters might be escalated to you. Do you see that?
Paragraph 20?
So at the top of the page, the question from me, you deal, Ms Musolino, at paragraph 23 of your statement of circumstances in which matters might be escalated to you. Do you see
Yes.
that? And then you respond yes. Then I ask you, by way of escalated to you, what are you referring? And your response concludes at the end of the section that's called out there. So escalation means bringing it to my attention. You see that?
Yes.
And then if we go to the next section, lines 20 to 31, call that out. And you agree with me there that circumstances in which matters would be escalated to you would be AAT1 matters where there was particular sensitivity and significance. You see that?
Yes.
You agreed with me about that?
Yes.
And I put to you that one such example would be a Tier 1 AAT decision identifying that a fundamental aspect of the scheme administered by the department was contrary to law. See that?
Yes.
And then paragraph 30, sorry, the next line, your response. You say it would depend on the exact terms of the AAT decision, but if the determination was that's what it represented, I would expect that it to be escalated.
Yes.
Consistently with those answers you gave, surely your expectation would have been for the matter that we've been discussing, particularly at length yesterday, to have been escalated to you.
It would have depended on whether the judgment of the lawyer or general counsel who was aware of the matter was that it fit the criteria that we've described. And I can't put myself in their mind. It would have depended if they judged that the effect of the decision was that the scheme was unlawful, or they considered that the matter didn't represent that. It would have depended on their assessment of that matter.
Well, assuming that was their judgment, then your expectation would have been that it would be escalated to you?
Assuming that was their if that was their judgment, then they likely would have escalated it to me.
And was it your expectation that it be escalated to you before or after the expiry of the time limit for commencing an appeal?
Well, it would have depended when they reached that conclusion, when they reached that state of awareness. I'd expect it to be escalated when they reach that state of awareness.
All right. Well, can you think of a reason, given how you've, given that you've now reviewed that decision in detail, can you think of a reason why the lawyer reviewing the matter would not have reached that judgment?
So the one we discussed
Yes.
yesterday, I think there would have been, so a reviewer at a junior level would have received the decision to review. They would have read the decision and applied the criteria under the standing operational statements and the litigation principles, and they would have come to a view, and they would have read the reasoning, and they would have come to a view about whether or not the matter should be appealed or we should make a recommendation for appeal or not. They would complete the FR template. I think that would then be reviewed potentially by another lawyer in the team at a particular level and settled and then dealt with. It may not have got any further than that. So if they concluded that there was no reason to appeal and no particular sensitivity at that point, it would not have been escalated, likely would not have been escalated to their general counsel or to me.
So even if okay, I'll take it in steps. So the AFR you know would have been second counselled by a principal lawyer?
I don't know if they were always second counselled by a principal government lawyer. I don't recall what the protocol was, but it would have been second counselled by somebody. It could have been an EL1 or an EL2. It might have been a practice director. I don't know, but it would have had some form of second counselling, I think.
As general counsel, wasn't it your responsibility to know what the protocol was?
I don't know. I know there was a protocol. I can't tell you what it is today. I haven't been in that job for a while, but I know there was a protocol.
Did you review the protocol at any stage?
There was a general protocol about second counselling. I would have reviewed it at some point. At some points, my recollection is it was amended from time to time. So I don't recall exactly when I would have reviewed it. I would have been aware that there was a protocol around second counselling, yes.
Right. So just to be clear, was it your expectation that an AFAR would be second counselled by a more senior lawyer?
I think that was my expectation, yes. I'm trying to remember what my expectation was at the time. I think there would have been some form of second counselling or guidance. I don't know if second counselling meant actually somebody reviewing the decision and reviewing the AFAR, or if it was a matter of them looking at the AFAR to see if it had been completed correctly. I don't know. I can't comment on the extent of the second counselling. I'd need to look at the protocol.
Okay. Well, you know who Brian Sparks is?
Yes.
He was a principal lawyer in the FOIL team, correct?
Yes.
He was sufficiently senior, wasn't he, to make a judgment on whether or not a matter needed escalation?
I think every lawyer in the team had the ability to escalate a matter to the next level up. So Brian would have had that expectation as well, that if he considered a matter to be significant or sensitive, he had the ability and the responsibility to escalate it.
And sufficient experience to recognise that this decision we've been discussing included reasoning that a fundamental aspect of the Robodebt scheme was unlawful.
Well, he had expertise. Whether he reached that conclusion, I can't comment, but he had expertise in the area.
And the general counsel at the time was Damien Brazel?
I don't know who the general counsel was at the time. I don't have that in my head.
Well, you know who Damien Brazel is?
I do, yes.
And you recall that at some stage he was general counsel for the FOIL team?
Yes, although I can't recall if he was substantive general counsel or acting general counsel. I think he did spend some time in that role. That's probably all I can add.
Okay. And would you accept that he had sufficient experience to understand that the effect of the reasoning in the decision that we've been discussing was that a fundamental aspect of the Robodebt scheme was unlawful?
Well, I can't speak to him reaching that conclusion. He would have had sufficient experience to be able to consider if a matter was sensitive or significant and required escalation.
All right. Do you have any memory at all as to whether or not this decision was brought to your attention before the expiry of the time for lodging an appeal from it?
I don't believe I've been able to locate any records that indicate that it was escalated to me at the time the decision was made or within the time period for appeal.
Okay. Do you accept that it was brought to your attention?
Yes. But at a later date, I should clarify.
After the expiry of the...
Yes, yes.
Can the witness please be shown Exhibit 4245, Doc ID, CTH.3039.0021.4507. Should be your tab 55, I think, Ms. Musolino. And it's an email chain that goes over a number of pages. All right, so if we could go to the last email in the chain. Call out that email from Mr. Fisher, sent the 24th of March 2017 to Ms. Bundy. Do you see that email, Ms. Musolino?
Yes. And you see the section headed decision. And you see there's a quote from, that's a quote from the decision referred to. I'll accept. Oh, sorry. Under the heading decision?
Yes.
That's a different customer though.
Yes.
Oh, sorry, yes.
The subject, by the way, is a third set-aside OCI case at AAT1 level. See that? The subject of the email?
Yes.
Can you see the words immediately after the number 23? The tribunal is not satisfied that this is an accurate calculation of the employment income earned by the person each fortnight. Rather, this allocation of income results in most unlikely and improbable fortnightly earnings. Do you see that?
Yes.
And you can see the email to Ms. Bundy just before the quoted section describes it as being interesting. See that?
Where am I looking? Sorry.
Just, it's highlighted on the screen.
Oh, sorry. The email to Liz.
Yes.
Yes.
And then the next email in the chain from Ms. Bundy says, "Thanks, Jeff. Really appreciate you keeping an eye on this. I've let legals know, Jim and Melissa know."
Yes.
See that? And then the next email in the chain on the first page, call that out at the bottom of the first page. Oh, sorry. Yes. And you see the note, "This is very interesting. I'd be concerned if legal services didn't contest this. If they don't, it will open up Pandora's box." Do you see that?
Yes.
And then the next email in the chain going up, Ms Bundy says, yes, agree that very careful consideration will need to be given to it. I discussed with Melissa last night. She was very pleased we had let her know as she has a meeting with the Minister on Monday. See that?
Yes.
And then the next email from Darren Zogalopoulos says, here it is. Essentially, the tribunal have determined there is no debt as they don't believe the customer worked through the debt. You see that?
Yes.
And then Ms Bundy, in the next email, I think this decision, another set aside OCI sets, suggests the rate calculators, at least in this case, does not support apportioning income across a period.
Yes.
And then the next email on the chain from Mr Brazel to Mr Sparks, dated the 5th of April 2017. He says, hi Brian, I think in the flurry looking into and the name of the case is redacted.
Yeah.
Is the version that you've got unredacted?
It's unredacted.
And you know
Yes.
the case? And that's the case we were discussing at length yesterday?
Yes.
Thank you. And then the email follows. I appreciate you're not in any of these email chains, but I suggest it's obvious to you that it was of significant interest to both Ms Bundy's team and also the legal team that there were a number of decisions of the AAT at Tier 1 level setting aside debt decisions.
Commissioner, before that question is answered, in fairness to the Commission and to Council assisting and where what may occur, Ms Musolino is copied in the second email in that document.
Thanks for that. Yes, I see it now.
I'm just checking this, Commissioner.
Well, Ms Hogan-Doran's perfectly right. You'll see to Brazel, Damien, Musolino, Annette, under sent Monday, 27 March 2017, 8:51 p.m. Do you want me to hand down a highlighted copy if you're having trouble spotting it?
Oh, yes. Thank you, Commissioner. I completely missed that. Ms Musolino, can you see your name in the name of the recipients in the second last email?
Yes.
Right, so what I put to you before was completely incorrect. You were included in these emails, at least until the last of the emails.
Yes.
So do you accept from me that there was significant interest on the part of Ms Bundy's team in a number of AAT decisions setting aside debt decisions?
Yes, and I think that's consistent with what I would have expected, that was the team that that had the authorised review officers making the decisions. They would have been keenly interested in decisions coming back from the AAT1. Yes.
And that was in the context of there having been significant media interest in the OCI scheme that year.
Well, I think it's in the context of their role was to manage Arrow and AA. The role of these teams was to manage this workload. So they would have been looking not just at these matters, but all AAT1 and Arrow decisions, not just on this program, but more generally as well.
And it was of such interest, wasn't it, that at least with respect to one of the cases, Ms Bundy discussed with Ms Golightly matter. That's the email on the second page, 26 March 2017, second last email.
Well, that's what she indicates in the email.
Yes, for the purpose of a discussion with the Minister.
That's what the email says.
And of course, given that level of interest by Ms Bundy, her team and Ms Golightly, it's not surprising, is it, that also members of the legal team were involved in emails about this topic?
It's not surprising, given the role of the legal team in relation to the AAT1 decisions.
And then if we go, please, to Exhibit 3544, Exhibit CTH.2001.0006.1296. Your tab 57, I think, Ms Musolino.
57. Yes.
Do you have that? That's an email from Ms Bundy to yourself, Mr Brazel and Alison McCann and others,
Yes.
dated the 19th of April 2017.
Yes.
And there's a statement that we are going to pull together the list of the 10 set-aside decisions relating to OCI. See that?
Yes.
It says we need to have a better feedback loop with these, I think, where we aren't appealing and how we are going to manage, and then ensure feedback goes back down regarding decisions. See that?
I see that.
And it says if we aren't appealing, then we are accepting the decision is correct, which means there is either new evidence, that's okay, but if there has been something we should or shouldn't have done along the way from the ARO down, we need to address. Do you see that?
Yes.
Do you accept that the effect of what Ms Bundy is saying is that a non-appeal from a decision is an acceptance, that is, a non-appeal from a decision of the AAT is an acceptance that that decision is correct?
I accept that that's what she is saying.
And that decision may raise a systemic issue?
Are you asking if that's what she's saying?
Yes.
She doesn't talk about a systemic issue.
Well, she says we need to have a better feedback loop, and talks about how we are going to manage and then ensure feedback goes back down regarding decisions.
That's what the email says.
And then talks about if there's no appeal, there needs to be an identification of whether something we should or shouldn't have done along the way down that we need to address.
Yes.
And doesn't that indicate that she's suggesting that there may be systemic issues in these decisions which may need to be addressed?
Given her role, which I think is the appeals branch at this point, my belief is that her interest would have been, are there things that the decisions are telling us about what's happening in terms of the decision making that we need to be having in the feedback loop? So it could be, are we not giving the AAT the right information? Are we not providing the right TDocs? Are we not explaining our position when we're making submissions? It could be, are the decisions actually not written sufficiently clearly? I think her interest would have been, how do we make sure we take learnings from AAT1 decisions and feed them back into the ARO process?
And wouldn't it be the case that in order to properly take learnings from those decisions, her team would need to be assisted by your division as to what legal conclusions could be drawn from those decisions?
They would need to take advice, and the advice was in the form of the AFARS process.
Right. And if the AFAR said no error of law, then that is no error of law with respect to the AAT decision, was it the case that the reasoning in that decision should be accepted by the department?
No.
Why not?
Because the role in doing the FR was to determine whether the matter should be appealed, whether there should be a recommendation for an appeal or the decision should be implemented, applying the criteria set out in the standing operational statements and the litigation principles. So not the department or the reviewer, so each reviewer would review each individual matter. They did not have to agree with the reasoning of the AAT one member to conclude that the matter could be implemented, and applying the criteria in the standing operational statements that they could that they would recommend implementation as opposed to an appeal. So they didn't have to agree with the reasoning. They had to look at, they had to read it, they had to have regard to it, but they had to look at implementation. Could they implement the directions of the AAT? They didn't. So the mere fact that they didn't recommend an appeal didn't mean they had to agree with the reasoning from the member in the AAT one.
But they had to agree with the reasoning as to what the law was in order to tick no error of law, didn't they? Otherwise they'd be making a misstatement.
Well, in my view, it depends what they're looking at. It depends what they know about that. But they may agree with a principle of law that that there has to be sufficiently probative material to make a decision. They may not have to agree with how the member has applied it in the particular circumstances or how that member's reasoned on it. So
If a member has reasoned that the Act operates in a certain way so that it doesn't have application in these cases, you can't tick no error of law unless you agree with it, surely?
I think that's how it worked. You didn't have to...
What, it worked that you could tick no error of law even though you thought there was one?
No, if the reviewer... So I can't judge what a reviewer is thinking about and looking at when they're looking at these decisions. You'd need to know what was in their mind, what other AAT decisions were they having in regard to. So they would have known about other AAT1 decisions, and they're reaching a conclusion that there's no error of law to justify recommending an appeal in that matter.
Well, how are they managing that when a number of these cases identify an error of law, which is effectively that a legislative regime is not being complied with? In other words, the legislative criteria to raise a debt are not being met.
Well, Commissioner, as I've said, they may
They just all got it wrong, or
well, they're following the criteria in the standard operational statements. As I said, they're doing a review. There's a lot of there's a lot of reviewers undertaking the reviews. They're coming to that conclusion based on the criteria that's been set, and it's hard to now try and look at one afar in the context of all of them and say, well, here's what the reviewer was thinking about when they made that call.
Well,
what we're concerned with, though, is a number of reviewers saying there is no error of law here when the decision has identified a failure to apply the law by the department. And so you have this consistent theme then that what the tribunal is saying about the law is correct, and yet the department persists.
And I wouldn't accept that it was a consistent theme.
Well, there are certainly a number of cases where the tribunal reached that conclusion which were never appealed, and we've seen some AFARs where somebody has cheerfully said no error of law. So
As I said, Commissioner, the decisions were cutting both ways. So I accept what you're saying, but the decisions were going both ways.
Okay, I think you're either missing my point willfully or inadvertently, but I'll go back to Mr Scott.
Thank you, Commissioner. Ms Musolino, just to make this no longer an abstract discussion, could the witness please be shown doc ID CTH.0010.0001.0020 exhibit 3483, which I'm hoping is tab 26 of your AAT cases bundle. Sorry? Your 24, I beg your pardon.
Sorry, 24?
Yes. You got that? You agree with me that is a AFAR?
Yes.
Data that identifies an appeal deadline of the 13th of April 2017.
Yes.
The name of the recipient, who was the applicant in the AAT Tier 1 appeal, is redacted, of course, on the version on the screen, but have you got an unredacted version in front of you in your bundle?
Yes.
Do you agree with me it's the same case that was the subject of some discussion yesterday afternoon?
Yes.
All right. And you can see that under the heading decision under review, the specific directions that we were discussed in that decision are extracted.
Yes.
And can you see the heading, sorry, the paragraph at the bottom of the page going over the next page? You see that?
Yes.
You recall being taken to the reasoning of the tribunal to that effect?
Yes.
And then if we go to the next three paragraphs, call that out on the next page. See there a summary of the reasoning that we discussed yesterday?
Yeah, can I just have a quick read of it?
Certainly.
Yes.
All right. And if you go to the bottom of the page under the heading Determination, there is a box ticked or marked with an X with reference to the statement, the matter does not involve an error of law or manifest error of fact.
Yes.
Now, do you agree with me that is indicating a positive conclusion that there was no error of law in the tribunal's decision that we've been discussing?
It says the matter does not involve an error of law or manifest error of fact.
Yes, which is a positive conclusion that the decision of the tribunal did not involve an error of law.
That's what it says.
Yes. Now, we go to the last page of the document. You can see who it's prepared, who prepared the document.
Yes.
A seconded lawyer by the name of Aaron Barrell.
Yes.
The next section under the prepared by section says it's cleared by. But
Yes.
you take it from me that the person who cleared this document in the event was Brian Sparks,
I don't know.
or just,
I'll accept it if that's what you're telling me.
yes.
I don't know.
and that the conclusions in this affair were agreed with by Mr Brazel.
I don't know.
I'm just asking you to accept that.
I'll accept it.
In those circumstances, given the positive advice, sorry, before I go on, I'll withdraw that. You accept that Mr Sparks and Mr Brazel would fall in the category of subject matter experts that you described yesterday, that is the subject matter experts in your team?
Mr Sparks definitely would have had the long-standing deep experience in social security law in this area. I think Mr Brazel had a broader experience from memory, so he would have had some experience. Wouldn't have put him in the category of a subject matter expert.
What about a subject matter expert with respect to administrative law principles concerning the lawfulness of administrative decisions?
I think he would have had a sound understanding of those principles.
All right. So, given the conclusion reached in this AFAR, wasn't it then incumbent upon the department to cease its practice of averaging?
No,
Why?
because that's not the effect of an AAT1 decision. So AAT1 decisions are merits decisions based on particular circumstances. We would not cease a program on the basis of a single member of the AAT1 reasoning in a particular way on an AAT1 decision.
Even though a general counsel within your, even though a chief counsel, I'll withdraw that, even though senior lawyers within your division, namely Mr Sparks and Mr Brazel, accepted as correct.
Isn't it Mr Barrell?
Brazel.
Oh, okay.
Mr Barrell, Mr Brazel and Mr Sparks all accepted as correct the legal reasoning in the decision of the AAT.
I don't know who Mr Barrell is, I'm sorry.
Well, no, you knew who Mr Brazel and Mr Sparks were?
Yes.
Okay. So even though those two accepted as correct the legal reasoning in the AAT decision,
Well, I don't accept that that's how they were constructing this. As I said, my understanding is they would have considered whether they could implement the decision. The mere fact that you don't agree with the reasoning of a single AAT1 member doesn't mean that you would necessarily seek an appeal. And the other thing is, I mean, this is a template document and it's a very short form. It doesn't have a lot of detail in it. And whether or not they considered an error of law, I think that the larger context is there an error of law that's capable of being addressed in the AAT2? And as I've already given evidence, an appeal on a matter like this to the AAT2 would not have concluded, would not necessarily, and I don't think would have, it likely would not have actually reached a conclusion on the reasoning of the AAT1 member. It would have been a merits review of that decision based on the individual facts of that customer. So that's probably all I can contribute to that.
so, but the issues would have been identical, wouldn't they, in an AAT2 appeal?
Well, the issue would have been, so the AAT2 would have been answering the question, is there a debt owed? If there's a debt owed, in what amount? And should it be waived or are there special circumstances? So it would have gone through that fact find and would have reached a conclusion on those questions. So the outcome would have likely been exactly, in terms of the directions to the department for the customer, the outcome of an AAT2 review would likely have been exactly the same as for the AAT1 decision, and we would have then implemented it. So it wouldn't have necessarily taken us any further.
And the AAT2 decision would have also considered the question of the lawfulness of averaging to calculate a debt?
Not necessarily, because the AAT2 is not bound by, it's a brand new fact find. They are making, they're standing in the shoes of the decision maker. So they may or may not have even considered the reasoning of the AAT1 member. They'd be looking at what is the correct and preferable decision in the case of this individual customer.
Well, given the opinion of Mr Sparks and Mr Brazel,
Commissioner, could I just raise for consideration my counsel assisting? I'm not sure that the evidence rises so high that there's been a positive establishment of Mr Sparks' opinion. It proceeds on the assumption that Mr Sparks has adopted this AFAR. Perhaps if it was put on that assumption.
I thought it was Mr Brazel's evidence that he had adopted it.
Sorry, we're talking Sparks now.
Yes.
Okay, so did Mr Sparks say he had adopted it? I don't remember, to be honest.
It was Mr Brazel's evidence.
Mr Sparks hasn't given evidence and there's no statement from him at this point.
Yeah, sorry. But there's nothing in the material from Mr Sparks. There was some email, I remember, but there's nothing from him adopting it.
And Commissioner, that's the email that I'm thinking of, and I'm not sure that that's where it rises. I may be in error, but that's my recollection.
No, I seem to remember his comments, but I don't think he descended to error of law, just that it wasn't sensible. Mr Brazel, what did he actually say? I just don't recall that.
I thought in re-examination, Mr Brazel said it had been cleared by Mr Sparks.
Oh, I see. Okay. So did Mr Brazel say he endorsed it?
Yes, that's my recollection.
He personally did. Well, perhaps it doesn't matter very much, but some senior lawyer in the department endorsed this view that there was no error of law, it seems. And we think it may have been Mr Sparks, but we're not sure.
Completely lost my train of thought, Commissioner.
No, I don't blame you.
Apologies, Commissioner, if I've
Look what you've done.
created that, but we're just looking at the transcript
Okay.
and trying to, of Mr Brazel, and I can't yet see the point that my friend is relying upon, point in the transcript. The relevant pages are in and about page 2386, 2385, 2386, 2387. And my friend said it was raised in re-examination. I'm just looking at the questions I asked of Mr Brazel and then the questions that my friend asked, and I don't see it rising in that portion. And that's on page 2388 over to 2389.
Look, in any event, it seems to me we're revisiting the same territory, which is that where you've got a position where departmental lawyers are happily ticking that there's no error of law, even though the legal reasoning should be enough to stop the department from what it's doing, obviously this system is never going to, the flaws in it are never going to be addressed, are they? You're set up to make sure that the legal problems identified by the AAT won't be addressed.
I don't think that's correct, Commissioner. I think the system is set up to ensure that decisions are dealt with quickly, expeditiously, etc., all the things that we talked about. It's a system set up to deal with volume, and I think...
But the fact is that the AAT was finding that averaging was not a legitimate procedure in cases, not all of them, but in some. And that proved to be perfectly correct, as the Solicitor General's opinion demonstrated. So that went on through 2017, 2018 to sometime in 2019 when around about March 2017 somebody could have been having a look at this. Is that a fair summary?
Yes, by March 2019, that's right. We were.
No, not March 2019. March 2017 you were getting decisions from the AAT pointing to a problem.
But absolutely, and as you said, Commissioner, they were cutting both ways. So
Doesn't matter if they were cutting both ways. The problem was being pointed to. It could have been dealt with in March 2017. It wasn't until the end of 2019.
I accept that.
Okay.
I think you accepted earlier that you did ultimately have the decision that we've been discussing drawn to your attention.
Yes.
And did you read the decision?
My recollection, and I might need to go and look at my statement, but my recollection is that it was brought to my decision as one of a group of matters that I had requested information about. I think it was around 18 May 2017, although I could check my statement.
Can the witness please be shown doc ID CTH.3007.00006.1940? It's not yet an exhibit.
So what tab was that?
It's not a tab, unfortunately.
Have you got a copy? I've got a copy, so I can give it to Miss Musolino.
We've got a copy. Do you have that?
Yes.
Do you agree with me that's an email from Mr. Brazel to yourself dated the 18th of May 2017?
Yes.
And you can see reference to OCI debt cases with foiled comments regarding appeal,
Yes.
and reference to a copy of the decision in a matter with an appeal number of 2016 M103550.
Yes.
Thank you. All right. And that's the email you're referring to as where these matters were brought to your attention?
Yes.
And then could the witness please be shown exhibit, oh sorry, that should be made an exhibit, Commissioner.
Okay, well, I haven't got yesterday's exhibit list, so what's a handy...
Exhibit 4303A we propose.
Oh, I see, somebody's catered for it already, so it's 4303A on the list that I've been given. Okay, fine, you can have that number.
All right. The witness can now be shown exhibit 3460, doc ID CTH.3007.0006.1949. You see that, Miss?
Yeah, so what tab?
I believe it's tab 1 in your bundle, or AAT cases bundle.
Oh. Okay, yes.
We go, and do you accept this is the attachment to the email that we've just discussed?
Yeah, it's one of the attachments, I think.
Yes. The summary attachment. Do you
Yes.
agree?
Yes.
We go to the last page. Is your version unredacted?
Does my version is unredacted, yes.
To accept that the last entry in the table, although it's redacted on the screen, refers to the case that we've been discussing?
Yes.
All right. And is this the means by which this decision was brought to your attention?
Yes.
So returning to my question, did you read the decision itself?
My recollection is I wouldn't have read it on the day that I got it, so and I think I deal with this in my statement. So I received it on the 18th of May 2017, and I think I had requested it ahead of a hearing, like a parliamentary inquiry or a Senate. I can't remember the actual inquiry. So I would have received it on the 18th, as indicated in this email. I received case summaries. I'm not sure, and I received one of the cases, it looks like. So I don't know if I received that matter. I may have, but I don't know if I received that matter in hard copy that day. And even if I did, I'm not sure I would have read it that day.
But you did read it eventually?
I think at some point I would have reviewed, yeah.
And so therefore you became aware that the tribunal had reasoned that it was not lawfully possible to calculate debts using averaging in the way that it was being used in the Robodebt scheme, correct?
Well, I was aware of the decision and aware of how the member had reasoned in that decision, yes.
And that it reasoned in the way that I just suggested to you.
I think I can't recall now what I thought about it at the time, but I was aware of what the decision said, yes.
Were you aware of what the decision said? And it was obvious from what it said that it had concluded that it was not lawfully possible to calculate debts using averaging in the way that it was being used in the Robodebt scheme.
I would have reviewed the decision. I would have relied on the summary and the advice I got about the decision. My view would have been, I think, that it's the reasoning that got us to the reasoning the member used to make the directions that he made was based on reasoning that averaging ATO data was not sufficiently capable of forming a valid decision, and that's how he had considered that matter.
And from this summary, you were told by Mr. Brazel that an assessment had been made that there were no grounds for an appeal.
Yes.
And he didn't tell you that he had formed a contrary view, did he?
No. Well, this document that you've got is the advice from Mr. Brazel or his team. I don't know who compiled it. So it says no grounds for an appeal.
Right. So you, by that stage, were aware that views had been formed by lawyers within Mr. Brazel's team that there was no grounds for appeal from a decision of the AAT concluding that averaging could not be used lawfully in the way that it was being used in the Robodebt scheme.
I was aware that they had reached that conclusion based on their assessment under the standing operational statements, yes.
So by that stage, did you continue to have a lot of assurance in your mind that the use of averaging in the way that it was being used in the Robodebt scheme was lawful?
Yes.
Despite the opinions reached by those in the Freedom of Information and Litigation team?
So, as I said, how we interpret the view that there's no grounds for appeal or there's no error of law depends on what's in the mind of the person doing the review. What I was comfortable with was that was reasoning in a particular matter by a particular member. Other decisions, and that's why we've got a list of decisions here, other decisions in this list don't take that approach. I was aware, and this is May 2017. So it's May 2017. The Ombudsman's report has come out in April 2017, which gave me assurance and confidence about the program. And the Department of Social Services view I still had in my head, or the advice that they had provided to us. So there was nothing in this that made me concerned that we didn't have a valid basis to continue averaging.
So
What
you,
about the case of 15th of March 2017 on the second page, 2016 S103 893? Tribunal finds no debt exists, questions method of income averaging, suggesting this process does not comply with section 1073 of the Social Security Act. Similarly unperturbed by that, I take it?
Well, I'm looking at all the decisions, and by the same token, other decisions in this list where averaging has been used, the tribunal, in a number of them, there's more information, and that's typical of what happens in the AAT1. By the time we get to the AAT1, more information is brought forward, so they're making decisions on a different factual basis. But the members aren't saying, look, I'm going to make it on a different factual basis, but averaging is unlawful. And this is not, the other thing about this is these are not all the AAT decisions that we're making. They are a subset.
No, but there are two there that should alert you that there's an issue about the legality of this, and it seems that, and it's enough to be the subject of discussion amongst lawyers in the department, it seems, and others, the appeals section, and yet nothing happens.
Well, and you're right, it's subject of discussion. We're having the discussion, but that doesn't lead us to a conclusion that it's legally invalid to make a decision in that way.
but the last decision listed on this table specifically reached that conclusion, correct?
The reasoning used by the member reached that conclusion.
And the Freedom of Information and Litigation team had concluded that there were no grounds for appeal from that decision.
Yes.
So regardless of whether or not there are other decisions going a different direction, your own team was agreeing with the assessment of the tribunal in that case.
No, that's not how I'd characterise what they were doing. So the fact that you don't recommend an appeal is not equal to the delegate or the Department of Social Services Secretary accepting that the approach is accurate. They're accepting that the decision shouldn't be appealed given the criteria that's in the standard operating standards, standing operational standards. So I don't accept that that is what that means.
Well, the language in the document doesn't use the words no appeal recommended. It uses the words no grounds for appeal.
Yes.
And a ground for appeal would be error of law, wouldn't it?
It's one of the reasons that you would recommend an appeal under the standard operating standards, standing operational standards, is one of the criteria that you look at in weighing up whether you're going to recommend an appeal is whether there's an error of law.
Well, it's not just one of the criteria, it's a ground for appeal.
It's one of the criteria that they're looking at. So they're concluding that there's no error of law. As I said, it has to be seen in the context of AAT1 matters, which are merits review. There's no ground of appeal that would actually lead to a changed outcome. And I think we need to think about it in that context because I think that's how it was thought about.
Do you agree with me whether or not there's an error of law is a threshold question on whether or not there's grounds for an appeal?
I'm not sure I agree with that. You could have grounds for appeal that didn't involve an error of law.
Yes, fair enough. I withdraw that question.
Okay, but I won't revisit it. Look, I think we've got Ms Musolino's position on the AAT appeals or lack thereof pretty clear. Can we infer that you never did find it necessary to refer anything to DSS or appeal anything, or?
I don't know. So I expect there would have been conversations at officer level because these matters were going on every day, not just these matters, but the whole AAT workload. I expect there would have been discussions between Department of Human Services officers and DSS.
But you'd been brought into this discussion loop. So what did you do from there on in? We know where you were at May. You were getting reports of cases. What happened? Nothing.
Commissioner, I'm in a job that has a lot of different practice areas. I'm engaging in this as it's brought to my attention, but I'm not running the team and I'm not reviewing all the decisions. So I needed to assure myself for the purposes at that point on 18 May, I wanted to get some assurance about, so I'd asked for some set-aside decisions to get a sense of what was going on. I took advice from my team and I was comfortable that what we were doing, given all the other things I mentioned, the Ombudsman report had just come out.
Who in your team told you this is all perfectly fine?
The primary people I was dealing with would have been Mara Stipnieks, who had a very, very deep knowledge and expertise in this area. So he would have been advising on the administrative law side. And I don't think Mr Brazel managed the litigation branch for very long, so I don't recall now who was in that space, but also from the litigation branch. So I'm relying on those experts.
Okay, so Mara Stipnick says nothing to see here, no cause to send anything to DSS or raise the prospect of an appeal, does it?
Well, I don't think I got a recommendation that we should do anything differently or that we should be seeking an appeal. We understood, or we believed we understood the position, the legal position that we were relying on.
Which you could only have got from the 2017 DSS advice, which said next to nothing. Because the Ombudsman's not a legal opinion. The Ombudsman may have gone along with the 2017 advice, but it hardly gives you a legal opinion.
It's a combination of factors. It's that advice, it's the Ombudsman, the fact that it's been scrutinised, it's the fact that there are AAT decisions supporting the practice, and so it's all of those things. And I'll add, and the Ombudsman Office is continuing to scrutinise all during this period, so it's all of that.
Can I ask this, Ms Musolino? Did you cause the Ombudsman to be informed of what was happening in the AAT?
At what point? I don't...
Before the April 2017 report?
We would have just responded to the questions and the material that we're asked for by the Ombudsman's Office.
Because the Tier 1 AAT decisions are confidential, aren't they?
They are. I don't know if the Ombudsman could have obtained them if he had wanted to. I don't know what his powers in that regard would be. But I think if we'd been asked for that information, I don't know if we were asked for it and I don't know if we gave it.
But you were having regular meetings, weren't you, with the Ombudsman?
They were quarterly liaison meetings.
Okay. Did anybody say, guess what's happening in the AAT? We've got a real conflict of views about this.
I'd have to go back and look at every meeting and see if it came up. But I know that there was, so the Ombudsman's Office would identify what were called issues of interest, and and they'd keep a running table of issues of interest, and they were getting complaints in this area, so they would have had an issue of interest around this. And those quarterly liaison meetings were not the only opportunity for discussion with the Ombudsman's Office. The office was constantly giving us what were called Section 8 notices or requesting information about a whole range of matters. That would have been happening at a lower operational level, so it may have been occurring.
Did you understand that the department had a duty to assist the Ombudsman in its inquiry?
Yes.
Surely informing the Ombudsman of what was happening in the AAT, even without a specific request concerning that issue, would be a necessary step to assist the Ombudsman in that respect.
Well, as I said, the Ombudsman's Office, I assume we're talking about when it conducted the own motion review.
Yes.
The Ombudsman's Office told us what they wanted and what information they needed, and we gave it to them. So I consider that we complied with assisting the Ombudsman in that inquiry.
But you're relying on, as part of your level of assurance that averaging was lawful, the report of the Ombudsman inquiry, correct?
That helped give us assurance about our position regarding the legality, yes.
As a basis for dissuading you from having concerns about the AAT decisions that indicating averaging was unlawful?
No, it's actually, I think the question was around why did we continue to hold that view? And it was that the Ombudsman's Office had looked at this issue and hadn't considered that it was unlawful or improper.
The Ombudsman didn't consider the implications of the AAT decisions, did it?
I don't know what the Ombudsman's Office concluded. I know they were requesting information from us. I know they were requesting information from the Department of Social Services. They may have requested information from the AAT. I don't know. And I actually don't know if they would have requested copies of AAT1 decisions from us in any event. Given that they were confidential, they may well have made that request.
Well, if they had made that request, you'd expect some comment about it in their report, wouldn't you?
I don't know. I don't know what they requested.
If you're moving on to something else, I can tell you it's just about time for the morning tea break. But if
Well, Commissioner, I don't expect that we'll be finishing this witness today, as there's other witnesses that have to be interposed. It's proposed that the witness be recalled in the next hearing block. There's one matter, though, as a matter of housekeeping, I need to address, which has been raised, that is some additional corrections to the witness's statement.
yes, okay, you were going to produce something for us yesterday, Ms. Musolino, and I can't remember what it was.
Yes, I've got it. It has been produced. Oh, sorry.
Oh, good, thank you.
Oh, yes, Commissioner, we provided the list of corrections yesterday, but we didn't reach it. In relation, it was a query in relation to communications from the Ombudsman and some media coverage. We provided that email and media coverage to Council assisting this morning before the
Oh, good.
before
Thanks
the
very
hearing.
much. Thanks,
It's
Ms.
been checked with
Musolino.
Ms Musolino, and it is what she was considering, but I understand my friend's deferring those questions to the next hearing block.
Okay.
That's so. Can the witness please be shown this document? Ms Musolino, have you got a letter from the Australian Government Solicitor dated 30th of January 2023?
Yes.
It refers to a statement tendered on the 30th of January. It refers to the various statements of yourself tendered on the 30th of January 2023. You see that?
Yes.
And then draws attention to various typographical errors
Yes.
and matters of clarification.
Yes. They're mainly typographical, I think.
And may we assume that you have reviewed the contents of this letter and are satisfied it's true and correct to the best of your knowledge and belief?
Could I just read it? Because I haven't seen it before. I'll just have a quick read. Yes.
Thank you. And you're satisfied with the contents of that letter?
Yes.
Commissioner, may that be given an exhibit number of 4303 capital B?
Yes. Yes.
Thank you, Commissioner. That takes us as far as we can go with this witness today.
All right.
Commissioner, I assume my friend, I'm not sure what my friend's position is in relation to Ms Musolino being held on her summons. Perhaps I might have some communications with my friend over the morning tea as to
Okay, you can
to
let me know
determine the
after
scope of any communications.
Anyway, that's it for you for the moment, Ms Musolino. So I'm afraid we'll have to see you again at the end of the month or early next month. By which I mean the end of February or early March. We will break until 11:45.
Royal Commission is now in session. Please be seated.
Yes, thank you. Commissioner, I now appear with Ms Berry and Mr Freeburn for the remainder of the witnesses today.
All right, and,
Commissioner, I appear with Ms Nicholas for this witness.
right, Mr Goh, I've already got you on the record.
Yes, Commissioner.
Right, thank you. Anyone else that I need to know about? Okay, thank you.
Yes. Commissioner, it's convenient at this point, before Ms Miller is sworn, if I tender the balance of the exhibits for the day. They commence at numbers 4304 on the draft through to 4620, the end of the list.
Yes, those exhibits will be admitted with the numbers in the list.
And I can indicate that Ms Rachelle Miller is in a position to commence.
Right, Ms Miller, would you prefer to take an oath or an affirmation?
I'll take an oath, thank you.
Okay, can you stand up and the oath will be administered?
Please place your right hand on the Bible. Your response is, I do. Do you swear by Almighty God that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, take a seat. Yes, Mr Gregory.
Yes, thank you, Commissioner. Can you tell the Commission your full name, please?
Rachelle Jane Miller.
Ms Miller, were you served with a notice to give a statement and produce documents dated 22 December 2022?
Yes.
And did you produce a statement in response dated 18 January 2023?
Yes.
When you produced your statement at the time that you completed it, did you have any access to documents from the period of time which the statement relates to?
No, I didn't.
That is, the statement relates to the period of time when you were a media advisor in 2016 and 2017. You didn't have any access to your emails when you completed the statement,
No,
or any access to departmental documents?
no.
Is it fair to say then that the statement which is produced is entirely reliant on your recollection?
Yes.
Since that time, have you had the opportunity to see some documents
Yes.
in terms of emails within the department and perhaps including you that have been released to your solicitors?
Yes.
And also some departmental documents.
Yes.
Is there anything that you would like to alter in respect of your statement?
No.
All right. Are the contents of it true and correct to the best of your knowledge and belief?
Yes.
Thank you. As I indicated just then, Ms Miller, you were a media advisor so far as the Commission is concerned in 2017
Yes.
and 2018.
Commissioner, can I just indicate for the record that, as Mr Gregory has pointed out, Ms Miller has had access to some documents, but there are many hundreds of others in the hearing book which she has not had access to and not had a chance to have access to.
Thank you. Yes, Mr Gregory.
Yes, thank you. Solicitors assisting the Commission have prepared a bundle which is before Ms Miller now, and should she require any additional time to review and consider documents, that will occur on the way through.
Okay.
All right.
Ms Miller, when did you first start work as a media advisor?
As a media advisor, full stop, or as a media advisor? Oh, I started working for Dan Tehan MP in early 2010.
And did you continue in various roles related
Yes.
to media advisory work
Yes.
for a period of years then?
Yes, quite a few.
And did that take you through to the 17th of August 2016 when you commenced as a media advisor for the Honourable Alan Tudge MP?
Yes.
You remained in that position, that is, with the then Minister until 28 November 2017, a little over 12 months?
That's right.
Okay. And where, or rather, who were you a media advisor to before that time?
Okay, so I started with, David Hawker, who was the previous member for Wannon, and then when he retired, I was employed by the new member for Wannon, Dan Tehan. And then when the Coalition won government, I moved to Canberra to take a role with the Attorney General, George Brandis. So I was his media advisor for a while, and then moved to Richard Colbeck's office and then to Alan Tudge's office. And after that, I then went to Michaela Cash's office.
All right. I take it the experience before you commenced with Mr Tudge in August 2016 then involved a wide range of media activities and advisory activities for ministers.
Yeah, absolutely. In fact, I'd worked for George Brandis, who was a very senior cabinet minister throughout, the 3 tranches of national security legislation, metadata, so really big media policy issues that were happening. So I was, a very long-serving media advisor.
Were you the only media advisor during that period, or did you have some assistants?
Cabinet ministers have more than one media advisor, but just regular ministers only have one.
And so when you commenced with Mr Tudge, were you the sole media advisor?
Yes.
The documents before the Commission refer to him as Sarah Bland.
Yes.
What role did she develop over time?
So over time, at first I was alone, and then it was seen that the media demand being created by the minister was really high, and I just couldn't manage the volume on my own. So we decided to he decided to promote Sarah Bland from being the electorate media advisor to an assistant advisor in Canberra. And she had some policy responsibility and also assisted me with the media. So that was a good help.
I propose to deal with your evidence in 2 parts. The first is to review some passages of your statement and explore those issues, and the second is to turn to some documents contained in the bundle before you.
Okay.
What do you recall of the period soon after you started with Mr Tudge about his focus on media, if any?
Oh, well, there was a lot. There was a huge focus on media, and it was made very clear to me that that he intended to prioritise media. And when I first joined him, we discussed a strategy around how he approached media, because every minister is very different. And so when you change jobs, you're not really doing the same job. What you're doing is you're working for the minister and his wishes when it comes to media. So some ministers don't like to do a lot of media, and they, George Brandis, for example, when I worked with him, would decline about 95% of media opportunities that came his way. He was more focused on his role as the Attorney General and didn't really feel the need to constantly go out and promote himself in the media. Whereas Alan took a completely different approach, and of course for me that was a big shift. And that was, to be honest, one of the reasons why I was interested in working for him, because it was an opportunity to actually be more proactive as a media advisor and learn more. You're not learning a lot as a media advisor when you're just declining media opportunities. So, he was known throughout the building as being very media focused. Actually, they used to call him a bit of a media tart, but I thought that was probably good for me because it would be a chance for me to develop my skills. But the first couple of months were really rough in that the constant criticism and the constant kind of demand from the minister to be doing more, to be achieving more, to be finding more media opportunities for him.
Within the social services portfolio, there was another minister, Mr Porter.
Yes.
What can you say about the relationship between Mr Porter as the senior minister in the portfolio and Mr Tudge?
Oh, they were very close.
And in terms of the division of media opportunities, what can you say about that?
Well, it was interesting actually, because traditionally the senior minister would have done most of the media opportunities about policy, and particularly in the case of DHS. Many previous DHS ministers, as I said in my statement, have taken an approach that they're there to deliver policy in the agency, and the senior cabinet minister does the promotion of this new policy that we're doing for social services. So Alan's approach was different, and they kind of took a 50-50, we do this together approach. So you'll notice that in a lot of the media conferences we did, Alan was always there with Porter rather than Porter. And in other portfolios I've been in, that's not been the case, where the junior minister is also there. It's usually all left to the senior minister. And there were cases where Alan was doing media that perhaps Porter should have been doing, but they seemed to have an agreement with each other, and Tudge would call Porter and go, I'm going to do this, can I do that? So he was very ambitious about taking media opportunities that strictly would have been Porter's.
Did Mr Porter have his own media advisors?
Yes.
One or two?
Two.
Who was the senior person there?
Kevin Donnellan.
And did you have much contact with Mr Donnellan?
Yes, on a daily basis.
And did your interactions with Mr Donnellan reflect the interactions between the ministers?
Yes.
Did you give Mr Tudge any advice about where he should spend his energy in terms of strategic or significant relationships?
Yes, I did. Given that he had made it clear to me that he was intending to use the media to boost his profile, and speak about the significant reforms that were happening in the department at the time, he was definitely... sorry, can you repeat that last bit of the question? Sorry, it's just gone out of my head.
That's okay. My question related to whether you gave him advice about strategic or important relationships
Yes.
in the context that you've described.
Yes, I recall we had a discussion about that ambition of his to promote himself in the media and use relationships with more senior cabinet ministers who were already there to advocate for him joining them in cabinet. So, and I said, well, you know, a good way to do that is to be seen to be having wins in the media for the government. So, you know, scoring good stories in the main newspapers about the achievements of the government and the reform agendas of the government, and particularly stories in what you'd call the left-wing media. The right-wing media. So you're talking about Murdoch Press or the Australian Daily Telegraph, Herald Sun, because that was, you know, kind of where the votes were.
What then of the minister's relationship with the secretary and other persons in the department?
Well, to my observation, he had a strong relationship with the secretary, and they had an advice I did give him was regarding that relationship was that if you want to achieve what you want to achieve, you absolutely have to have a partnership with your secretary. And you know, there can be conflict between ministers and secretaries when ministers are wanting to pursue a policy agenda and a secretary is not on board with that. And that didn't at all appear to be the case with the minister and the secretary. They seemed to really agree on the direction they wanted to take in terms of policy reform.
And the secretary during this period of time was Ms. Catherine Campbell.
Yes.
Ms. Miller, were there persons within the department with whom you had regular contact?
Yes, the media team. So the heads of the media and strategic communications teams.
And who was the head of the media team?
Oh, that was Bevan Hannan.
And the strategic communications team? Or was that one team?
Yeah, that was Scott Robertson. Sorry, it's in my statement, but I can't recall the surname. Scott Anderson.
And how often would you be in contact with Mr. Hannan?
Oh, daily, definitely, multiple times each day.
And did that continue throughout the little over a year that you worked with Mr.
Yes,
Tudge?
Bevan and I got to know each other very quickly.
In your statement, you refer to the Minister and staff in the office being provided a daily media report from the department. Can you describe that in some more detail, what that comprised?
That would be a collation of the relevant media clips, i.e. a copy of an article that had appeared or a radio transcript that appeared that day, relevant to the portfolio. And that was done by a media company called Essentia.
This was an online service?
We could access the portal online, but we were sent an email that contained a PDF that had all of the pages of the media articles for the day.
In your experience as the advisor at the time, was the provision of that material comprehensive?
Yes.
That is, it covered everything that was relevant to your role and the Minister's role?
Well, it did, but there were occasions when it would miss an article.
Okay. How often would that occur?
Look, fairly frequently, because it was based on, searching for key terms and things. It might miss an article if perhaps something's come up that appears to be outside of social services or human services portfolio purview, but actually does, relate. So often it was perhaps a new article about a topic that wasn't ongoing. So, I mean, for example, the media coined the term Robodebt pretty quickly, and so to more accurately obtain a search, the DHS would have, human services, social services, welfare as sort of key search terms, but also Robodebt, so that would then make it, a more successful search. Whereas if a new issue came up, maybe we'd miss that.
And to your knowledge, would the Essentia email be sent to the Minister directly?
Yes.
And to your knowledge, did the Minister read it?
I think so, but I used to send him a text message after I'd gone through it all with the key issues of the day anyway, and the key issues that really kind of were important in the day were highlighted in the email from the Prime Minister's office called the Morning Note. And so he was more focused on the Morning Note. The media clips I'd always print out for him in a folder, and I'd put them on his desk with the Morning Note on the top, so he could go through and see quickly the key stories across politics, if there are any key stories in our portfolio. And then the media clips, they picked up a lot of things. They picked up a story perhaps from DHS about a new Centrelink office opening, or some procedural things that weren't really politically related. So I would definitely say he didn't read all the clips every day, no.
But there was, as you say, something that came from the Prime Minister's office?
Yes.
And who generated that document, to your knowledge?
The Prime Minister's media team.
And that was sent to all ministers?
All ministers and all media advisors and other selected staff.
And you yourself would conduct your review of media on a daily basis?
Yes.
And provide copies of directly relevant material to the Minister?
Yes.
On a daily basis?
Always. I did that as they happened. So if a news story broke, it was easy when it was just all newspapers and that was the media for the day, but with online stories, it's constantly breaking news. So we did have some breaking news updates that came through from the department throughout the day. I think there was a morning one and an evening one. And then I was also constantly monitoring Twitter for any kind of breaking stories that were going up online. So I have my own search methods, including Google Alerts and that type of thing.
Can I turn to the topic of media releases or media statements, interviews, those types of things? What degree of involvement did you have firstly?
Well, journalists would contact me if they were requesting material or lines or a media interview with the Minister, and I'd assess all of the options that were coming in and recommend to the Minister, look, I think this has come in, I don't think you should do it, or I think you should do it. But generally, I made him aware of the majority of, almost all of the requests that were coming in, unless they were just, something that he would never have the time to do, like an interview with a small community newsletter or something like that. So, but I did try really hard to make sure that he was aware of the volume of requests and things that were coming through, so he could get a sense of, how much in demand I suppose he was for media opportunities, and we certainly grew the demand quite significantly. And that's just the reactive side of the work I did. So a lot of the work I tried to focus on was, and the minister was very strong about, which was to get us out of a reactive cycle and just reacting to what was coming in the media, what was coming along in the media, and put us into a proactive cycle where we were determining what was going in the media, and we were publishing stories and working with journalists to, publish exclusives that would then set the media narrative. So they're two very different concepts.
Just on that last point, did that require you to cultivate relationships with journalists?
Yes, extensively, and actually search through what was going on in the department for any potential story ideas. Is there something interesting happening in the department that perhaps, the policy team or people in the department working on something don't realise that actually that's something that would be really interesting for the minister to talk about in the media, because that's not their expertise. To recognise it's a policy or a program that they're working on is actually something the minister might want to talk about. So I was very proactive in speaking to Bevan about, I need you to actually go into the department, find ideas for stories and come back to me. And the minister was certainly very instructive over that. In fact, to the point of when I first came on board, wanting a kind of weekly report on my ideas, my proactive ideas for stories. He had this kind of, give me your top 3 story ideas for the week, and most of the time they were crap, quote unquote.
Returning to the topic of ministerial releases, for example, who drafted those?
The department drafted them, and then they came up to our office, and I then edited them, gave them to Minister for sign-off, and then they went out when they were ready to go out.
In your experience, did the minister closely review media releases and media statements?
Yes, extensively, to the nth degree. In fact, I can recall staying up until about 1 o'clock in the morning in a hotel room in the Gold Coast reviewing a media release for like the 8th or 9th time.
Okay.
Which I might add is kind of counterproductive, because most journalists don't actually read any of the media releases that come into their inbox.
You indicate that your first recollection of knowing about the Robodebt scheme's existence was from a conversation with Mr Hannan.
Yes.
You commenced with the minister in August 2016.
Yes.
How soon after you commenced did that occur?
The conversation about the Robodebt scheme?
Yes.
It would have been around November, because maybe it was October, late October, because the first story we placed about Robodebt was in November, and I can't recall the precise date, but it was in The Australian.
Okay. And what did you make of the information provided to you by Mr Hannan?
Oh, well, I took one look at it and went, there's a good story here. You could see that it suited the government's narrative perfectly of, putting in place policy initiatives that saved money. And that was a big focus of the government at the time. We were all under pressure to find budget savings in every portfolio, but particularly human services, because obviously the bulk of taxpayer spend is in human services. So we're under a great deal of pressure there, and I think that I saw that as a good story opportunity. Also, the estimates from the pilot of the dollars that we were recouping from recipients who had debts was significant. I can remember being quite stunned by the figure and thinking, Minister Cormann's going to be very happy about this.
I take it from your recollection then, Mr Tudge hadn't raised the scheme with you prior to that point?
No.
The pilot you refer to, was that a period of time in 2015 and 2016?
Yes, I think so. I mean, what I was told was that it had been in a pilot, the pilot had been successful, they were now looking to ramp up the scheme.
What steps did you take in respect of the accuracy of the information that you first learned from Mr Hannan?
Well, I went back to Bevan and I said, look, can you make sure that this is really accurate? The minister also said to me, once I'd told him, look, I've gotten this information from Bevan, it looks like a good media story. He, of course, was like, it looks like a great media story, but make sure you go back and double check, triple check to make sure that that is actually right, that that's exactly what, that the pilot has been successful, there are no problems with it. And so I did do that, and Bevan came back to me and said, no, it's all good. I mean, that's why we're going to ramp it up. We've had the pilot, it's been tested, it's working as planned, so we're going to ramp it up.
Did you receive assurances from anyone else in the department?
Not to my recollection, no. But saying that, Bevan always acts on the okay of the line area deputy secretary. So he wouldn't tell me that it was okay unless he had heard that from the policy team.
That is the process as you understood it.
Always. That was the process as I understood it, yep.
Involved the head of the media team confirming information relevant to the particular area within the department.
That's right. We used to call it the line area. Yeah.
You said that there was a publication early on, I think November you said?
Yes, November. That was really the first story about the scheme's existence. Aside from, obviously, media releases had gone out in the previous governments about data matching, but this, we sort of badged this as something new.
And that was reflected in the media release?
Yes.
And that is the minister's media release and also the journalist's story?
Yes, yes.
And do you remember which journalist it was? Or which paper it was?
It could have been Sarah Martin, but I can't exactly recall. Okay. It was The Australian.
The Australian. To your recollection, did the OCI, or Online Compliance Intervention Scheme, as it was then described, receive adverse media publicity in late 2016?
Yes.
And do you recall what the sense about that was, or what the response was in the Minister's office?
Well, whenever there's a proliferation of negative media stories about a particular minister's portfolio area, there's always deep concern, and the priority is to shut that down. So yes, there was concern about the stories were coming up. However, I did note that it was predominantly in the left-wing media. I mean, it was entirely in the left-wing media at that stage. And, you know, we weren't too concerned because it wasn't unusual that the left-wing media were attacking us regarding social policy.
Where does the ABC fit in all this?
I would have said that they were in the left-wing media camp.
Oh, okay, just checking.
You say that you weren't particularly concerned. Why is that?
Well, I mean, we understood that people who, you know, had received a debt and who had been issued with a debt notice might be a bit annoyed or a bit grumpy about receiving a debt notice. And we knew that a lot of the people who were receiving debt notices were going into their local MP's office to get help with liaising with Centrelink. And a lot of those people were going into Labor MP's offices to liaise, to get help to liaise with Centrelink. So, of course, anyone going into a Labor MP's office with, oh, I've received a debt notice and I don't have a debt, is going to be something that Labor are going to be feeding through to the media. So that didn't surprise me, but we tended to believe that these people were either just having a bit of a whinge about having to repay a debt or being caught out, or there was some error in what they had provided to the government that led to that debt, and we were encouraging people, look, if you have a debt, just go and contact Centrelink.
Do you recall Mr Tudge engaging with media, a current affair in December 2016?
Yes,
And Triple J hack?
yes.
What do you recall of those media engagements?
Well, I recall that they were different, that the Triple J hack interview, I think, was actually mentioning some people that they knew, some case studies of people who had gotten debts, and did the minister think that that was fair? And I think the Triple J hack interview was very much focused on particularly students and younger people who were getting these debt notices and didn't know what to do and perhaps didn't have the records, you know. So it was more sympathetic to people who were receiving debt notices, whereas a current affair review interview was very much focused on, sending a clear warning message out to people that the coalition is cracking down on welfare cheats.
The minister took leave sometime in December due to return mid-January.
Yes.
In his absence, was Minister Porter acting in the role or
Yes,
taking
he was.
over responsibility for the role?
Yes.
What do you recall of the period before Mr Tudge returned from leave?
Well, I was supposed to also be on leave, and I worked every single day right through Christmas because the media demand was just growing and growing and growing. And we were also receiving a lot of calls from the office, into the office, from people who had debt notices and were ringing saying, well, this debt's wrong. So the DLOs were very busy with calls, trying to sort out people's issues. And it was extremely busy.
It might be convenient to describe who was in the office at this point. You referred to DLOs, that's a department liaison officer.
Yeah, and there was virtually no one else in the office. I can recall just me being in there for a lot of the time until I went on leave, and then I was working from the house we have, my parents' house at the beach, north of Sydney.
How many departmental liaison officers were there?
Two that I can recall, but perhaps sometimes I think the department used to send up an extra if there was kind of the need for a sort of surge capacity, if that makes sense, until the department then set up the hotline. There was a hotline or something, and then they said that the DLOs should just refer all people through to that particular hotline that dealt with people who had received a debt notice.
Also within the minister's office there was a chief of staff.
Yes.
Who was that?
Andrew Aston.
And a policy advisor.
Yes.
Who was that?
That was Mark Wood. But they were both based in Melbourne, so would not be in the Parliament House office unless it was a sitting week.
I see. How were the DLOs able to deal with people who rang up directly?
Well, they had access to all of the department systems on their computers at Parliament House. So they're actually able to act like a customer officer and get into people's files and actually see what was going on and try to work through an issue with a customer.
You said the media demand was very high while the minister was on leave.
Yes.
The media was generally adverse to
Yes.
the OCI scheme.
Yes.
That is, it was heavily critical.
Yes.
Would you say that by January 2017, so far as you were concerned as a media advisor, the media situation was in a crisis mode?
Yes, but I didn't think that it was not able to be shut down. Yeah.
And how would you go about shutting it down?
Well, I developed a crisis media strategy at the request of the minister. I would have done it anyway, but that's what we did. He was very firm with me that I needed to shut this story down.
Can I pause you there? Were you in contact with the minister while he was on leave?
Yes.
Okay, this is email contact.
Email contact, yes. And the minister became quickly aware that the Prime Minister was unhappy with, you know, the sort of escalating media issue around this. And Minister Porter, at the time when Minister Tudge was away, we were trying to sort of decline as many media opportunities as we could, obviously, because the main minister was away, Minister Porter was around, but obviously everybody was trying to have a bit of a break, so we were trying to just contain it, I suppose, at the time. But that media strategy was quite comprehensive that I developed in January to shut down the story, and that involved, you know, placing stories with the, you know, the more friendly media, the right-wing media, about how the coalition was actually catching people who were cheating the welfare system. And that media, including the likes of A Current Affair or others, has a lot more reach. The commercial television programs, the 2GB radio, that type of thing, has a lot more reach. So actually the message that was getting to people on the ground was that the coalition is cracking down on welfare cheats, whereas in the kind of, you know, left-wing Canberra circles, it appeared to be quite a crisis. But we were getting feedback from the Prime Minister's office that actually this was playing quite well in you know, marginal seats, Western Sydney, that type of thing.
Which was playing quite well.
Well, the narrative of that Robodebt was actually playing quite well in terms of people actually supported it and were supportive of the notion of the government cracking down on anybody who was cheating the welfare system.
I might just ask if your statement could be brought up. It is behind tab, an unnumbered tab. I think it's documents identified by the Royal Commission. And if we could go to the page ending _0006.
Sorry, did you want me to refer to that in here?
No, it's just going to be brought up on the screen.
Okay.
Sorry, that's me talking to the document manager.
Right, yep.
You describe a counter-narrative there between lines 10 and 20 with various dot points. Is that what you're
Yes.
talking about?
Yep, absolutely, yes.
And you identify that the narrative was going to be run in more friendly media. You identify the Australian and the tabloids,
Yes.
which had their
And
own.
the, you know, 2GB sort of shock jock radio stations.
And the readers or listeners for those types of media, you describe them as Australians who tended to be swinging voters as well as the coalition base.
That's right.
Okay. You identify 4 points in the counter-narrative. This is the crisis strategy that you developed,
Yes.
and they are set out there. The third dot point, can you outline the background to that? Or the purpose behind that?
The purpose of that, I mean, obviously that's a political hit.
Yes.
And that's what it was intended to be. It was intended to sort of say, well, Labor, you're complaining about this system, but actually this is a system that was in place when you were in government. And that was a very strong defence that the minister used in question time against any questions that he got. And what the system actually did was go back over debts that were accumulated during the Labor years. So it wasn't just looking at debts that had happened, you know, recently. It was going right back, and I can't remember how far back, but the system was able to go back in time and locate where people had perhaps incurred a debt. And we use that as a political point to sort of say, well, look, the Labor Party just let these people go. They didn't do anything about identifying these people, whereas we're being much more proactive and we're going to go back in time.
The fourth dot point refers to new technology such as data matching.
Yeah.
I'll take you through some documents in some time, but do you recall the language around that changing to what you've just described, that is that this has been around for ages rather than a new program?
Well, that's what's interesting. Data matching had always occurred between ATO data and Centrelink data. The difference was that we were able to do it much faster because of new technology that was available with the Robodebt system. So the whole idea was that this was an automated system. And that was what was so new about it. And then obviously ministers often do this, they'll rebadge programs that already exist, but because they've made a change or a tweak or an upgrade to them, they'll badge it as a great new system. That's quite common.
Thank you. If that document can be taken down. You said one of the things that you did in a practical sense was to use real life examples.
Yes.
What do you recall of that aspect of the strategy?
Well, again, that was used pretty extensively in question time, and it was also used extensively across the media as a defensive tactic to kind of. So and the minister was really very forceful about obtaining these case studies. He was very adamant with me that I needed to hunt down as many case studies as I could, and that he wanted the details on all of the cases that appeared in the media, and that he wanted to understand whether they were OCI debts or whether there were other debts. And we'd broken all of that down into a sort of a spreadsheet of information where he could sort of say, well, of 50%, and this is not a right statistic, but as an example, more than 50% of the people who are claiming in the media that they have debts, they're actually not even robo-debts. And so it was a defence of the system, but it was also able to say, and the system tracked down, 42-year-old male from New South Wales who told Centrelink he'd only earned $10,000, but actually the Robodebt found that they earned $100,000, So he was able to sort of put the suggestion back on the Labor Party that, well, what? You're saying that this person shouldn't have been caught. You're saying that we should just let these debts go. So that was the way in which we were able to kind of, throw back to Labor that, you would let these guys go. You would just happily give them taxpayer money that they weren't entitled to. And it was also used to create new data sets on how effective the scheme was that we could then give to the tabloid papers. So there were quite a few stories around that, around the case studies and the amount of people we were catching.
So what did you do to implement the minister's direction about getting case studies? How did you go about that?
Well, I briefed Bevan and said this is what we're looking to do, but I think also the minister was pushing our policy advisor and chief of staff as well to get into the department and find as much evidence, statistics, case studies, information, data on exactly who was being or how many people were being detected under this scheme.
And we've moved on a little bit in time, I understand. This occurred after the minister returned from holiday?
Yes.
That is January 2017?
Yes.
Do you recall the minister saying anything to you along the topic of making sure that the information that was given to him related to real debts or verified debts?
He wanted to make sure that the information he was receiving was accurate,
Yes.
and that he understood whether it was a debt that had been raised by the OCI or Robodebt, or whether it was a debt that had been detected by another method. So not all of the debts were debts that were detected via Robodebt. So he wanted to have a clear understanding of the details of the data sets.
You refer in your statement that there was a strong focus on preventing people going to the media by ensuring the department was fixing any issues as quickly as possible.
Yes.
How did that work in a practical way?
Well, the minister was very firm with the DLOs, and that anybody who was contacting the office who was a new case, so someone we hadn't heard of in the media or whatever, that their issue gets sorted straight away. And so he instructed the DLOs to make sure that that case was then going into sort of the priority queue of people who were able to be dealt with by a Centrelink caseworker, I suppose.
And by intervening in an early stage, that prevented them.
Yeah, that prevented them from getting more angry and then going and, venting to the media.
You refer also to, in your statement, to the engagement of PwC.
Yes.
What do you recall of how that came about?
Well, I recall that there was discussion in the office about engaging PwC to look at some of the technical issues that may have been occurring with the scheme. And I recall giving my advice that that was a great idea, and the reason being, from a media perspective, that is a really good idea for the minister to be able to go out and say, well, we're acknowledging that there's a bit of an issue, but we've got independent experts in there taking a look at it, so I'm not going to make any further comment until I see their recommendations. And it's a really good holding line for a minister, and you'll see them do it quite regularly. When there's a bit of a media blow-up, they'll announce an inquiry. And that then enables them to, and every other minister, to be able to say, well, I understand there's inquiry happening there, so couldn't possibly comment about that issue. And it means effectively that they can not answer journalists' questions.
You referred to getting a report or updates from the independent consultant. To your recollection, do you ever recall a report being produced to the minister while you were there from PricewaterhouseCoopers?
There was supposed to be a report produced, but while I was there, I never saw that report. I did hear in conversation that there were...
What, are you talking now about the period that you were there?
The period that I was there.
Okay, yes.
In conversation, I heard that PwC had made some amendments, some initial suggestions about how to improve the system, which was that the wording of the initial letters was very harsh and very attacking, and that we should reword the letters to be more, hey, we've just noticed that there's a discrepancy, could you please get in touch with us and we can work that out, rather than you have a debt, you need to pay by this day, So that was one of the suggestions I remember. But beyond that, I didn't know much more about the PwC work until I joined PwC after I left Parliament.
I won't deal with that period of time. Do you recall where the idea came from to engage an independent expert?
I don't. But given that the minister is a former management consultant himself, it wouldn't have surprised me if it came from him, although I think PwC were already engaged in other areas of work in the I&I branch, so perhaps it came from one of the departmental officials. I don't know, sorry.
You said I&I?
Well, I think that's the is it Information and Integrity branch? I can't remember exactly what it was called. I just remember I&I, group or branch or division, or I don't know.
That is an area within the Department of Human Services.
Yes.
What do you recall of the topic of releasing personal information from persons with whom Centrelink dealt to the media?
So we didn't think of doing that at all, ever, because when I first joined, because we understood that the personal details of any Centrelink recipients was confidential and that we weren't able to release any information. It was a little bit frustrating, actually, because you'd read a media story, you go to the department and say, well, what's going on with this person? Once you got the full story, you're kind of like, well, the media article's quite misleading, but we've got no way to correct the record. Well, we've got no way to defend ourselves, so we basically just said nothing. And then when a journalist approached me about a...
Can I just pause you there? I suspect you're about to describe a journalist from the Canberra Times. The name of the person that's the topic of where you're about to go, I think, has been redacted from the document. So
okay.
Just refer to
Thank you.
an author.
An author.
Yes.
Yep. So the author of a piece in the Sydney Morning Herald or The Age had written a piece. I had a journalist contact me and say, well, this is disgraceful. What she's describing here is, just this person is describing is disgraceful, and how is it that your minister could let this happen under his watch, and what has Centrelink got to say about this? And I said to him, well, and he said, look, I'm going to write another piece about this first piece because I think it's so disgraceful. And he said, can you, though, assure me that what that author has written is correct? Because I'm not going to just report off something I've read if I'm not sure that it's correct. And that's a usual process for journalists. And I said, well, I can't confirm it's correct. And he said, so what, you're saying that some of the things that are said in that article are not true? And I said, yes. And he said, well, that's interesting. Is there any way that you can let me know what they are? And I said, well, no, because of the privacy issues. So, but I said, but it's an interesting question because I get this question a lot. I might just put it to the department and say, well, how is it that somebody's able to go out in the media and say something highly defamatory and false about the department, and the department has no ability to be able to correct the record? And I think, I sort of said that kind of looks like it would erode public confidence in our in our departments, who are taxpayer funded. So I requested Bevan to just go and find out. And he came back to me verbally and just said, oh, well, it looks like there is a way we can release specific details just to correct the record, just to correct the public record. And I said, oh, well, okay, if I was going to do this, in this case I would, point out X, Y, Z. Is that able to be cleared by the Chief Legal Officer, Annette Musolino, for us to do that? And it came back, yes, you can. So the legal advice to us was that we were able to do that, but just the specific pieces of information. You couldn't just, hand out their whole file to the media. It was just specific lines that contradicted what had been said in the original piece.
And was it the case that you were able to come to a view about there being incorrect statements in the media because a file in respect of that person was already in the Minister's office as a result
Yes.
of the publication?
Yes, the Minister requested the file of every single person who appeared in the media.
Right.
So that we could see the exact, transactions that they'd had with Centrelink and understand what the details of their case was.
You indicate in your statement that if we were able to correct the record, it would send a strong message to others who are making incorrect claims to stop, and therefore it was a component of the crisis media strategy we had employed.
Yes.
What do you mean by that?
Well, the Minister was adamant that if there were things being reported in the media that were incorrect, that we should correct the record on every case. So he was very strong with me about doing that, and that was a lot of work.
And what impact did you anticipate that would have generally?
Well, generally, that was my belief that, and my feedback to the Minister was that this would send a clear message to perhaps people who have been sent to the media by Labor MPs, that maybe consider it twice and make sure that what you're saying is accurate and true.
Because if it's not,
Because if it's not, we'll correct the record.
do you recall reading media articles about the decision to release personal information from that point
Yes.
that were very critical of that approach?
Yes. Yes.
All right.
And I think that's when the Labor Party referred it to the AFP.
Yes. What did you make of those criticisms in terms of your crisis strategy?
I wasn't too worried about it. It was not surprising, the outrage from, the left-wing media. That didn't surprise me at all. I mean, they would be outraged about something like that. And I wasn't particularly concerned about it. All I was concerned about that we were able to do it legally.
Did you notice any impact of the decision to release personal information into the media upon the nature of media stories from that point?
Yes.
And what was the impact you observed?
Well, there were less people speaking out in the media, which was the intention.
There was a distinction, though, wasn't there? In some cases, you released case studies without identifying
De-identified
details.
case studies, yes.
But there was another instance that Mr Gregory's been talking about where the name was part of
Yes.
the information.
That's right, because that person had authored a piece in the paper.
All right. Is that the one that led to the drop in people speaking out, or is it a more general effect of all the releases of information?
Oh, I think it was that particular case and the publicity that got, that we were going to do this, that sent that message.
So you could find your name in the paper being contradicted on what you'd said, effectively, if you...
Well, if you've gone out to the media and put your name to false statements, then yes.
The determination of what was false or incorrect, where did that lie? Who made that decision?
With the minister.
And ultimately the lines that were determined to be made available to the media publicly, who cleared those?
They were cleared by a policy advisor and then taken by the media team. So I'd send them back to Bevan. He would then go and seek approval for them from the relevant line area and the legal team.
And then they'd make their way...
And it'd come back approved. And particularly in the case of that person whose name was identified, that there was formal signed legal advice that we were able to release those details.
And was that something you asked for specifically?
Yes.
In your...
The minister asked for specifically, and I also requested specifically.
I understand. The adverse attention that decision drew, you describe it in your statement as a risk that was taken at the time.
Yes.
And what was the nature of the risk?
Well, I mean, it wasn't usual practice at that stage for ministers in that portfolio to do that. They would have just done nothing. They would have just said nothing. There weren't, to my knowledge, many previous cases of people using that particular loophole in, I think it's in the Privacy Act, but not exactly sure, which enables, government agencies to release information for the purposes of correcting the record. I think it was that kind of loophole existed, but I don't think it had been used that often, although I didn't do any research to find out whether it had been or not. But it was a risk. It was a risk taken because we're at the point where non-risky, first plan A's were not working, so we're going to plan B or we're going to plan C. And then as that goes along in media strategy, it becomes more of a risk. It's certainly, obviously for me, in retrospect, not something I would do again.
And what compels, as you say, plan A to not work or B to not work? How does that arise?
How is that determined?
Yes.
Well, I mean, the usual strategies of us, putting out counter narratives or us putting out comments in media articles that, reputable journalists will always seek comment from both sides of a story. And so it was always my reputable journalists will contact me for lines from the minister, even if they're going to write a story that's very negative. However, there were certain elements of the left-wing media who weren't even doing that. And that's kind of unethical on their behalf to sort of run, attacking stories and not even contact the minister's office for comment, because most stories are supposed to present both sides of the story. Minister says this, person X says that. And that's balanced reporting. A lot of the reporting was very unbalanced. And so we were kind of going, okay, this isn't working anymore. The usual, use of the media, the usual relationships I have with journalists are not working. And that this particular group of journalists are being quite vindictive, being very biased and unbalanced. And so, we had to do something to try and tackle that. And I had a lot of conversations with those journalists during that time.
You refer in your statement to the concept of the narrative and being in control or being lost.
Yes.
Where was the minister's narrative at this point?
Well, I mean, we were still receiving assurances from the Prime Minister's office that the message that we were cracking down on welfare cheats was going well in key areas like Western Sydney, but that we had a continuing media crisis in the left-wing media that wasn't seeming to die down.
And was it that in that context this decision was made?
Yes.
The
decision, I've got to say, was also made for me, for that particular individual, because I did trust the reporter who was going to write up that rebuttal of ours. He was a very reputable journalist, and writing for Sydney Morning Herald Age. So I felt that he would deal with it professionally.
By the way, that was not a Robodebt case, was it? It was somebody who'd been complaining about Centrelink and the way they managed things and dealt with their clients. Is that correct?
I think that's correct, but I can't recall exactly. I do recall the headline, Centrelink terrorising me, something along those lines.
And your observation at the time had the effect of shutting down the personal stories which were appearing
Yes.
in the media, which were critical
Yes.
of the scheme.
Yes. There were still the occasional story that would come up, but it wouldn't receive the kind of follow-up that the previous stories were receiving.
The question of inaccuracies or incorrect debts, did that ever come up in the minister's office?
Yes.
And in what circumstances were you first made aware that there may be a potential issue about accuracy?
Well, that would have been in late December when I was sitting with a DLO who was on the phone to a customer, and she said to me, look, from the information that this person has now provided, it looks like her income has been averaged. And that was the DLO, Rachel Dryden. And I said, oh, okay, but that appeared to me to be a very, what would I say, crude way of identifying a person who had had a debt. And it seemed to be more like a system that you would use to identify a general pool of people who were potentially suspicious, but it seemed to me that that was an easy way to pick up people who, once they provided additional information, actually didn't have a debt. But I was assured that that we were then assured that that was the way the system was the system was operating as intended.
And was that assurance from someone in the department?
From Bevan Hannan. But I did tell the minister, look, this is exactly what appears to be happening. And once people come to us with all their pay slips, the debt is often reduced or completely cancelled. And the minister was well aware that that was happening. And to the point where there was a staffer in Minister Chester's office who was quite young. I think she was an assistant advisor. And she came to me one day in the bathroom. She said, "Oh, you work for Alan Tudge?" And I said, "Yes, I do." And she said, "I really need to speak to you because I've been sent a debt notice." And I was like, "What?" And she said, "Yeah, it's from my days when I was a student. I was working variable hours, over Christmas break I'd work full time, and then other times during the term I wouldn't work at all. And I've got this debt notice and I've got all my pay slips and everything here. Can you guys help me out? Because I don't have time to go down to Centrelink office." So I put her in touch with our DLO, and her case was able to be her debt was completely wiped once she provided all of that pay slip information. Now, it was lucky that she was obviously quite diligent, and kept all of those documents from back, quite a few years back. It was 4 or 5 years back when she was a student. So that alarmed me a little bit, because I thought, well, if a ministerial advisor with, multiple degrees, strong work history even when she was a student, obviously fairly educated and savvy, has only been able to work out her debt from having kept very accurate records, I did start to wonder how the bulk of people who received welfare payments were going to manage that.
Did you bring that specific example to the attention of Mr. Tudge?
Yes.
Do you recall what his response was?
Well, his response was, "Well, good, it's been sorted out, so that's good, and that's exactly how the system is supposed to be working. I.e., we are putting out a kind of general call to people that, hey, there's a discrepancy and we're missing information here. Can you please provide it?"
Did you discuss with him, or the DLOs, or the policy advisor, or the department, what might happen for people who hadn't kept pay slips or didn't respond to the debt letter?
Well, then it was yes, I did, and to my knowledge it was, well, the debt stands. And I didn't really understand what the legal thinking was behind that, or what the policy thinking was behind that, but that's what I was being told from the department. So, and as a media advisor, it's not my job to question them about policy issues. So I was just like, okay, I'm going to trust that you guys know what you're doing.
And to be clear, I understand your answer to be that of the people I identified, that communication occurred with someone from the department.
Yes. I also did try to seek assurances from the policy advisor, but again, he was very firm that, hey, this isn't your job.
That is Mr. Wood.
Yeah, Mr. Wood, yeah. He was like, it's a policy issue, I'm speaking about it with the department. So I was like, okay.
During January 2017, who from the department regularly attended the minister's office?
Oh, well, Catherine Campbell, I think, was there on a regular basis because she was set up in the boardroom almost permanently, I think, and Melissa Golightly. I can't recall specific other people. There were lots of people, and it depended on, groups of people were brought up depending on which deputy secretary and which group that particular issue. So I know that the technical people were coming up, and Craig Storin from the technical side of things, and I've just recollected that name now, and then also people from the policy areas. So that's, and the integrity, the I&I branch. There was a lot of people.
The minister, I think, was due to return from holidays in approximately mid-January.
I can't recall exactly, but it might have been later January.
It seems he returned on about the 10th. Not
Yes,
the
he
10th.
returned early, yes,
And why was that?
because the Prime Minister asked him to return immediately to deal with the Robodebt issue,
That is the crisis
the
situation.
crisis, yep.
To complete your recollection before the lunch break, Ms Miller, what do you recall of, if anything, during your period as a media advisor to Mr Tudge, of the persons having committed suicide after receiving debt letters or being caught by the Robodebt scheme?
So I was aware of media articles saying that people had committed suicide as a result of receiving a debt notice. And all of those cases were looked into by the minister. From memory, some of them were Robodebt cases and some weren't. There was lots of different reasons why these people had received debt notices, and it wasn't exactly clear. Some of the articles were very misleading and kind of suggesting through the style of reporting that the person had committed suicide because of the debt notice. But then there were other articles where family members had said, quote unquote, I believe that my brother, my sister, whoever suicided because of the debt notice they received. So there was a mix of articles from my recollection.
Did those reports have any impact on the extent to which the scheme was defended?
Look, I mean, those reports, first of all, were terrible and obviously, really tragic and upsetting for me in the Minister's office. There's not a lot that we can say in that area, but again, we just went back to our policy of if there's been things that have been said that are incorrect, that we'll correct the record. Beyond that, we're not saying anything. The details of those cases were very closely kept between the Minister and the Minister's policy advisor and the Chief of Staff, and I only saw bits and pieces as related to from memory, I only saw bits and pieces related to the media side of it.
Did you have any conversations with anyone from the department about the relationship between debt notices and suicides as they were reported?
Not that I recall.
It didn't appear to you that there was any reflection on the question of accuracy or fairness about the scheme when suicide was mentioned?
No, because we understood that a lot of recipients of welfare payments are, vulnerable people. They are people with perhaps pre-existing conditions that we had sent out a lot. There were a lot of debt notices going out. So, you've got a large pool of people and that, but yeah, I mean, it was concerning. It was definitely concerning.
Never mind fairness and accuracy. What about the sheer impact on someone who's not expecting to be contacted about 5 years ago's debts and somebody who's vulnerable? Was that given any thought?
It wasn't. It wasn't. It was, and as I think I said in my statement, there was a distinct lack of empathy and that thinking around that thinking that putting yourself in a person's shoes, putting yourself in a person who is receiving a Centrelink notice, putting ourselves in their shoes. It didn't happen because that was the culture of the place. And that is one of the reasons, why I think that obviously I'm hoping that this commission addresses, because you would think that working in human services, social services, that the first person you think about is the recipient. But that was not the case throughout the coalition government.
Is that a convenient time? Because it's just after 1.
It is, thank you.
Right, thank you. We'll take the lunch break and come back at 2.
All rise. The Commission stands adjourned until 2 p.m. Royal Commission is now in session. Please be seated.
Yes, Mr Gregory.
Thank you, Commissioner. One matter of housekeeping earlier that I overlooked. It's agreed between Council that Ms Musolino would not be released from her summons, and there is agreement about who she might speak with in the interim.
All right, thank
If
you.
that needs to change, there'll no doubt be some discussion about it.
Certainly.
Ms Miller, just before lunch, I was asking you about the question of information about suicides which had reached the Minister's office and the general culture within the Minister's office.
Yes.
Can I take you to a specific example of that in the bundle? It relates to Mr Reece Corso. Do you
Yes.
recall that name?
Yes, I do.
Thank you. If you could turn to tab 108. Do you recall that there was an article in the Saturday paper written about Mr Corso following an interview, it seems, with his mother?
Yes.
And prior to the publication, there was probably the ordinary media or usual media inquiries with the department about the information.
Yes. Yes. We had warning. I think they'd come to us for comment before the story was published.
Yes. And
Yes, I can see it here.
yes,
Inquiry by the Saturday paper. Yep.
if Exhibit 4406 could be brought up, CTH.3034.0037.0813_R. There are redactions on the document, Ms Miller, but
Yes.
so far as they relate to Mr Corso, they might be beyond what's necessary. And you can see that there is a media inquiry which has at least come to your attention through the media team at the department on Thursday, 16 February 2017.
Yes.
And there are questions which are set out and the proposed response which is set out.
Yes.
And you responded to the media team after reviewing the material.
Yes.
To your recollection, would Mr Tudge have been aware of this inquiry?
Absolutely. Yes.
Would he have had any input into the response from the department?
He would have cleared whatever it was that we sent to the journalist. Yes.
Right.
And would have more than likely edited the response.
Mr Gregory, I understand Mr Corso's mother was all right with his name being used, is that right?
That's correct, Commissioner, yes.
Thank you.
Specific confirmation was sought and obtained.
Yeah, all right. Well, my thanks to her for that.
Yes. The next exhibit, 4407, it appears at the next tab, Ms Miller, CTH.3051.0016.4527_R. The article was published, I take it, on Saturday, 18 February 2017, at least according to the dates here.
Right. Yes.
And the information is conveyed to you by Mr Thomas, to both yourself and the advisor, Mr Wood, and
Yes.
copied into the departmental liaison officer, Ms Dryden,
Yes.
which is described as an urgent heads up in the email, which appears second in the sequence there.
Yes.
And again, there was a case study which was attached in respect of Mr Corso, following the usual practice of the Minister requesting case studies for it.
Yes. Yes.
Your response, I just wish to touch on its tone, if I can take that up with you, is fair to say it was a critical response of both
The article.
the journalism and the content?
Yes.
All right. What was the mindset, that is your mindset at the time, and how did that fit within the culture of the office?
Well, my mindset was that this was an extremely unbalanced piece of reporting. that it misled the reader, even in the headline of the article, to link the Robodebt system with other debt recovery activities. The fact that he clearly had a debt, it was definitely a debt. It was a debt that Centrelink had been pursuing for some time from my memory, and that there was no discrepancy about it, that the debt stood. And that's the difficult thing, I suppose, for people in the department, is balancing out, well, we've got a vulnerable person who perhaps for a multitude of reasons is not responding to Centrelink's correspondence or requests to liaise with them. But on the other hand, we've also got a duty to the Australian people to ensure that people are receiving the payments that they're entitled to, nothing more or nothing less. And in this case, in this particular case, it was clear that he definitely had a debt. So I was, and it wasn't surprising at that time that the Saturday paper would report in a very partisan way. Each Saturday there was just a hit job on the coalition government. So it was by no means a surprise that it was extremely unbalanced.
Can I clarify two aspects of your understanding at the time? In respect of Mr Corso, the certainty that you arrived at in respect of the fact that he had a debt, that was based on the information conveyed to you by the department?
Yes.
And in terms of the link between those debts and the circumstances in which they were recovered, be it OCI or a different method, did you understand that what preceded OCI was a manual version applying the same or similar business rules?
Yes.
Okay. But that the point you were making was that it wasn't an automated process under OCI, rather it was a manual.
That's right. There was essentially people involved in ensuring that it was correct that he had a debt, and obviously in terms of policy development and whatever comes out of this commission, it would be a useful thing to consider that balance between, dealing with a person who's obviously very vulnerable, but we need to ensure the integrity of the welfare system.
Can I get you to turn to the next document then, if that can be retracted?
Is that on the same tab?
No, 110.
110, right.
Thank you. Exhibit 4408.
Yes.
CTH.3051.00016.6834_R.
Yes.
Again, just while that document's being brought up, Exhibit 4408.
And just while we're waiting for that, I'll just mention that we'll take a break at 3:30 for 5 minutes because the recorders need a short break, which is fair enough.
Thank you.
Anybody else who wants one?
Sorry, I've just remembered I didn't answer your question about the culture
Oh, yes.
contributing to, and I feel, and I've written in my statement, it was certainly much more of a culture that was focused on ensuring integrity of the welfare system, making sure that all debts were collected, rather than considering too much about taking a sort of a welfare or counselling view to Centrelink recipients. So that did very much influence the way that we thought about how we responded to these types of things, although I will say that we were all very deeply upset that somebody had taken their own life, obviously.
Thank you, Ms Miller. The next document,
Yes.
4408, is the one on the screen before you.
Yes.
You can see this is about a week later. There is an email from yourself to Mr Tudge, 26 February 2017, which attaches the full case study from the department, and it's been converted to a plain English version.
Yes.
And Mr Tudge responds to you on the same day,
Yes.
identifying that the plain English version of the case study doesn't give a clear example effectively of when he was on, or doesn't say when he was on benefits, and it's always good to give a clear example of why a debt was raised, which was features missing from the case study on Mr Tudge's analysis of it.
Yes.
And then the last email in the trail
Yes.
is from the Chief of Staff
Yes.
to Mr Tudge, copying both Mr Wood and yourself in, advising against going through the details in public because it's a bad look to be discussing the wrongdoing of a person who committed suicide, you can see.
Yes.
And again, those were the sorts of discussions that were had surrounding events relating to suicide.
Yes.
Okay.
Yes, I mean, there was a discussion of the views of myself, Policy Advisor Mark Wood and Andrew Aston, but always the Minister had the final call. He was the one who decided what action would be taken and directed us.
I might return to your statement now, Exhibit 4305, if that could be brought up on the screen, and we could go to the second last page, _0016. Ms Miller, can I take you to the last paragraph on that page? It continues the theme of the last questions.
Yes.
You refer there to the recent impression you have gained or recent insight you have gained from evidence at this commission, that is the impact of OCI that it had on disadvantaged people's lives. Oh yes, and the second part of the paragraph from the next page is brought up. Is it the case that you had followed some of the evidence of the first public hearing?
Yes, yes, and I watched some of the victims give evidence, and it was a different thing, I suppose, to see and hear a person talk about the impact that debt had on their lives, and it really, it really upset me.
And did that response prompt you to make contact with a solicitor's firm and ultimately
Yes,
with a view to potentially giving evidence?
yes.
Right. Beyond the evidence of people who had been affected by the Robodebt scheme, had you watched evidence more generally?
Very small bits and pieces.
Right. Okay. I propose to now turn to a number of the documents in the folder. If
Okay.
you go to tab 3, again, Ms Miller, you've given a lot of evidence of your recollection this morning, and I just wish to confirm by reference to some of the documents, the material that you, or the evidence that you gave earlier today.
Tab 3.
Yes. Exhibit 4306, CTH.3830.0001.001_R. The date of the email, Ms Miller, is 18 October 2016. It's from you to Mr Hannan and the general media email address within the department. And,
Yes. Yes.
And you referred to an email earlier that morning from a Mr Jancic, who is described in his footer as an advisor to Mr Tudge.
Yes.
And the topic is the debt and compliance media opportunities.
Yes.
Was this email sent at about the time that you became aware of the OCI program and were identifying
Yes,
derivatives of the story which would be useful for
Yes.
the minister's promotion?
yes,
That is media promotion.
yes, that's right.
Okay. And you refer there to a media calendar.
Yes.
What was that?
That was something that Bevan Hannan and Scott Anderson prepared for our weekly meeting, and we would go through all of the opportunities that were in the media calendar. So that calendar was a calendar of opportunities that the department had identified, like maybe upcoming speeches or upcoming departmental events, or and I would go through it and say, well, yeah, the minister will speak at that one, or the minister will give a video message there, or the minister doesn't want to be involved in that. And so I've put this in to be discussed as part of that meeting, so it's sort of an agenda item.
I'll take you to Exhibit 4307 behind tab 4. CTH.3004.0002.3357_R.
Behind tab 4?
Tab 4, yes, it should be an email dated 22 November 2016.
Yes.
Can't see that you were a party to it, but it is from a Kristen Hannah. Do you recall her?
Yes, I do.
What role did she have?
From recollection, she was the band 1 in the department who oversaw the media and communications team.
Right. And it is addressed to Ms Campbell, the Secretary, and a number of others, including Mr Jongen.
Yes.
And I think I also saw Mr Hannan in there as well. It identifies the major media activity for the day in consultation with the Minister's office. Generally, that was a reference to you.
Yes.
And if we go down to the middle of the page, there's a subheading compliance. The Minister's office requested we revise a media release on budget measure milestones to focus on the success of the online compliance system. You see that?
Yes.
You recall that that was something that was considered and identified as a good opportunity to develop
Yes.
for media purposes?
Yes.
Thank you. And if you go to the next tab, it is Exhibit 4308, tab 5, CTH.3098.0009.6792_R. The following day, 23 November 2016, there was an email from the general media, email addressed to yourself, which attached a draft media release. I understand it to be a draft that promoted the department's new online compliance systems.
Yes.
And you'll see the attachment is over behind tab 6,
Yes.
Exhibit 4309. It's dated 23 November 16, but I suggest, if you can recall, that it wasn't published until about the 5th of December.
Oh, okay. Right.
Do you recall that there was an anticipation that the Minister would be able to make a media release as the target or the milestone was reached, but there was a misstep in communication from the department and the milestone was reached before the media release?
I think I recall something around that, but I'm not
specifically.
can't remember exactly what happened there.
But again, this followed the same theme of a positive
Yes.
story which promoted the Minister's profile
Yes.
and sent the message that you described earlier.
Yes, absolutely.
Okay. Here, there is reference in the first paragraph to some large numbers, and in the
Yes.
second last paragraph, the number of 4 billion over a 4-year period. Are those the numbers that you remember being quite surprised at in your discussions with Mr Hannan
Yes.
earlier?
Yes. Yes, it's a lot of money.
Can I take you to Exhibit 4310 behind tab 7? cdh.3108.0003.2788_R. An email from you to Mr Tudge, Sunday 4 December 2016, a little after midnight it seems, sorry, before midnight, where the attachment is described as Q&A's online debt and compliance tool. Can you just explain what that means? And I think the attachment is immediately behind tab 8, if that assists you, but Q&A's...
Oh, yes. Yep. These are basically what we would otherwise call talking points,
Right.
which are we write to prepare a minister for an upcoming media opportunity, or we may just give to the minister so that they can get the story, kind of straight in their minds.
And was it at about this point in time you were working to develop the article for the Australian newspaper? I might come to it in the sequence, but
Yes,
speaking
yes.
broadly,
Yes.
was there an
Yes.
anticipation there would be media talking points because of media opportunities?
Yes, that's right.
And Q&A just stands for question and answer.
From my recollection, the story in the Australian was in November.
Right.
But
All right. And so there are some short dot points in the email which put OCI in a positive light, similar to the draft media release you saw.
yes,
And if I can take you then to, sorry, before I move to the next exhibit, while that's pulled out, a lot of what's, the language used there is what you've described in your evidence earlier.
yes, that's right.
Thank you. The talking points, or the Q&As, Exhibit 4311, cth.31080.0003.2789. Who drafted those, or where did they originate from?
They would have originated from the department, but often what would come up from the department would be quite long and detailed, and I would go through that and edit it and cut down the lines to make sure that they were in a format that Minister Tudge wanted. So, I mean, the department would send up Q&As that would be, from a departmental perspective, non-partisan. They couldn't put any political language in these or anything like that, and then I would edit it and add that if I felt it was required as an answer, but otherwise just shorten what the department was saying into, more. I mean, the whole idea of talking points is that it's written in a way in which the point would be made verbally in a media interview, so there needs to be sort of short, sharp lines. But these are quite long, so I suppose we were giving the minister a little bit more background here.
To your recollection, the extent of the understanding by the Minister's office, I'm talking about media advisors, yourself,
Yes.
DLOs at the time, about the detail of the scheme, was that understanding quite limited?
It was for me.
Yes.
As a policy advisor, as a media advisor, but it shouldn't have been for our policy advisor. Our policy advisor should have all of the details of a policy which is in his portfolio,
Right.
particularly one that's getting attention in the media.
Was your understanding limited to the content of these types of documents and your
Yes.
interactions with DLOs
Yes,
and what was conveyed to you by an advisor or the minister?
yes,
Okay. Or the department, Mr. Hannan?
yes. And I mean, on OCI, I mean, that would be, the most comprehensive information I'd have is the substance of a document like that Q&A's document.
Okay. Tab 9 contains Exhibit 4312, CTH.3001.0030.6414_R. This is the media release dated 5 December 2016, and it has your name at the bottom.
Yes.
That indicates that it's followed its usual process for publication.
Yes.
And again, if you can turn over to tab 10, Exhibit 4313, RBD 9999.0001.0368.
Yes.
This is an article which appeared in The Australian on 5 December 2016. The author was Sarah Martin,
Yes.
and you can see the title and the content.
Yes.
Is this the same article which was in your memory in November, or is this a different one?
This is the one that was in my memory in November.
I see.
It's obviously 5th of December, as I can now see.
Okay. And in terms of the content leading to publication, do you know where Ms Martin got her content from?
Yes, from me.
Okay. You obviously knew Ms Martin?
Yes. So I gave her the media release as so she could run it as an exclusive. So she got what we call a drop or an exclusive from us to run the story, and then we issued the media release as soon as the story went live. And then other media might have picked up on the story throughout the day. I think the minister might have done a few radio interviews. I can't recall, but that was a common practice. Rather than just sending out a media release and hoping that a journalist might just pick it up, you then take away the exclusive. If it's an exclusive, it's more likely to end up on the front page.
I see. And I take it Ms Martin was one of those journalists with whom you sought to cultivate relationships.
Yeah, absolutely.
To increase the minister's profile.
Yes, yes.
There are quotes in here attributed to Mr Tudge. If I just take you down to 2/3 of the way in the first column, you can see it commences, Human Services Minister Alan Tudge said.
Yes.
It says he told things to The Australian. Again, was that information you provided, or does that derive from an interview process?
It could be quotes provided in the media release that we sent him,
I see.
or it could sent Sarah Martin, or it could be that she called him up and did a further kind of interview with him over the phone. That often, both of those things often would happen.
Right. That is, it would supplement the exclusive.
Yeah, that's right.
I see. I take you to Exhibit 4314 behind tab 11, CTH.3108.0003.3673, and Exhibit 4313 can be taken down. We're a little over a week later now, and from the review of this document, you will see that Mr Christopher Naus, K-N-A-U-S, from The Guardian, contacted the department seeking information about the online compliance system and had a series of questions in respect of a story that he was going to publish.
Yes.
I take it The Guardian would fall into the category of media that you described earlier as left-wing media or left-leaning media.
Yes.
And you can see that the email trail reaches Mr Tudge on the top of the first page, where after you ask him to clear lines for The Guardian.
Yes.
Was that usual, that lines in response to a request for a journalist would be cleared by the minister?
Yes, this is always what would happen. He would always clear lines that were going from him as you know, attributable to the minister. He cleared all of those. Sometimes verbally, but often via email or text message.
that is a very high degree of involvement with the content of the media release.
Yes, particularly when you have many, many, many media queries coming in every day and a minister with a packed calendar. So, as I said in my statement, often, he wasn't clearing things until after deadline, which was, then frustrating journalists and making it difficult for me. Often I was doing this stuff at quite late at night.
Towards the bottom of the page, under the subheading response,
Yes.
yes, thank you. The second sentence, or third sentence, second paragraph, the department is confident in the online system and associated checking process with customers is producing correct debt notices. Did that reflect the fact that there were articles critical of the accuracy of debts which were developing by that time?
Yes. Yes, otherwise I don't think they would have felt the need to put such a line in there.
Okay. And was it about this time, that is mid to late December, that you first had your concerns about the potential inaccuracy of the debt notices
Yes.
from the two experiences that you've described?
Yes. I mean, it's one thing to hear things written in the papers. It's another to actually, see the DLOs dealing with customers on the phone and seeing that issues are arising. So.
Right. The next document, 4315, behind tab 12, CTH.300.0023.5868 is a transcript of an interview, Triple J Summer Hack. You refer in your statement to Mr Tudge participating in these, and you gave evidence of that this morning.
Yes.
In this particular interview, 21 December, if you go to the page, the second last page, .5873, you'll see a question by Ms McVeigh towards the bottom of the screen, why are people being hit with a 10% recovery fee? And the Minister was not aware that was the situation. Do you see that?
Yes, I do.
Did that reflect in part that there was an incomplete understanding of what was actually happening at a departmental level?
Well, I mean, it seems to indicate that, given that the Minister said he was not aware. But I'm not sure whether he was aware or not aware of a 10% recovery fee.
Okay.
What about the drop into the Centrelink office notion?
Yes.
Had the reality of that been explored at all?
No, I think he just assumed you could drop in and speak with somebody immediately.
What was he doing on Hack? That wasn't really your constituency. Well, not the one you were describing at any rate.
No, the Minister has done Triple J Hack quite a bit in the past, and I did advise him that maybe it was a good one to do just before he was going on leave, because it might just kind of nip the issue in the bud, like kind of, if he does a good performance here, it gives other media and other journalists access to a transcript with his commentary, which they can then use. And so I thought it was a worthwhile opportunity to take, just to try and dampen down the story before he went on leave. And it was my understanding that he went on leave very, very soon after this interview. It might have even been the next day.
Tab 14, Ms Miller, Exhibit 4317, CTH.3051.0015.0646. You gave evidence about contacting the Minister by email while he was on leave. This email trail ends on 7 January 2017. And you also gave evidence about the Prime Minister's office
Yes.
invested in the time of his return. If we go to page 2, document, thank you, towards the bottom, your email
Yes.
from the 6th of January refers to the fact that you were still on leave at the time.
Correct.
And you're,
I'm writing an op-ed.
yes, and you refer to a sense of infuriation, but a strategy in the second and third lines of the need to put up a strong defence because you had a strong defence.
Yes.
And that is the way the department presented the information, at least to you, indicated that the system ought to have gained traction in the minister's favour.
Yes.
Right. You referred to an op-ed which you had drafted.
Yes.
And I think that's over the
Yes.
next page, which again was part of the strategy that you described.
Yes.
And then there is a sequence of exchanges between yourself, the Chief of Staff, Mr Aston, the advisor, Mr Wood, and the reference to Minister Porter, who was in charge of the portfolio at the time.
That's right, yes.
And Mr Tudge says at the top of the page, is PMO agitated about this? Mark, I need those notes they asked for ASAP. Have PM texting me about when I'm back. And I think you said earlier that he came back sooner than
Yes.
the holiday was due to end.
Yes. Yes.
Because of the crisis.
Yes.
On page 1, and that is 0646, there are various questions which appear to be asked by the Minister and various dot point responses.
Yes.
One of those questions was, what time period is the data matching done? I.e., does it look at every fortnight of the year in question and match your stated income via ATO income, or every 4 weeks or every 26 weeks or whatever? Then there's a dot point answer. The ATO provides data for every reporting period, brackets fortnight, for the year to produce an annual figure. And there are various other questions
Yes.
were on the Minister's mind, which some preliminary responses were given to.
Yes.
And those questions and those answers, would you agree, give a good indication of at least the Minister's understanding, or the extent of the Minister's understanding and the advisor's understanding at that point in time of the system?
Well, given that that was authored by the advisor, I think that that would have been what he chose to tell Minister Tudge.
Yes.
I'm not aware that, I mean, Mark may have had more knowledge than that, but this is what he was choosing to inform the Minister. And the Minister may well have been talking to the Secretary or Deputy Secretary at the same time without our knowledge. He regularly did that. He would just call the Secretary if he wanted to know something. So I can't exactly say that this was the only knowledge he had.
All right. The attachment is refers to Plibisec Shorten 2011. I'll come to it shortly. But at the bottom of that email, Mr Tudge asks, did Labor do any debt recovery work in their time in office? Presumably they did some, but obviously not as symptomatic as what we are doing. A typographical error, probably systematic.
Yes.
And there are 2 dot points in response. One refers to a data matching process with the ATO, which was introduced by the Labor government in 2011, and the media release is attached. And then there is some additional information which appears to be extracted from that.
Yes.
Okay.
Yeah.
If we go to, you can see, just for your purposes, tab 15 contains the talking points which were attached.
Yes.
And, in fact, might bring those up. Exhibit 4318, CTH.3051.0015.0649. The third paragraph commencing Centrelink is simply doing. You can see that.
Yes.
You talked earlier about a political hit and the way in which old measures were tweaked and rebadged as new measures and
Yes.
put back
When
on.
they're inconvenient, then they were.
And when it was
Oh,
inconvenient.
definitely Labor's measures.
Right. And it was the development of that line of media strategy, as it were,
Yeah.
to try and quell some of the
Yes.
crisis surrounding the issue.
Yes.
Did you all understand the difference between data matching and debt calculation? I mean, the media release that you were pointing to was just about data matching. Job itself doesn't.
Look, I don't know that. I mean, I knew that data matching was what they were using to detect potential debts, but I wasn't aware of the process beyond that. I would like to assume that my policy advisor understood the difference.
Okay, thank you.
To be specific about it, just in this document, while
Yeah.
it's there, you can see the paragraph just below halfway commencing, debts are only raised.
Yes. Yes.
That could be called out. Again, it refers to the concept of averaging income based on information held by the ATO because there has been no update provided by the recipient. And it's only in the absence of other information that income is averaged over a full year. And again, this method of determining and calculating a debt is precisely the same method that was used by Labor when they were in government.
Yes.
Putting to one side the factual correctness of that talking point,
Yes.
did you understand at this point in time that the advisor, the junior advisor from Mr. Chester's office, had her income averaged over a period of time? Was that the nature
Yeah.
of your conversation with her in December?
Yes.
Was, yes.
Yes. Yes.
Okay. And in terms of the source of this talking point, was that something that would have initially been drafted or was initially drafted by the department and then came
Would
to
have
the minute?
been edited by myself and definitely the policy advisor. Because if it was talking points, I had to check with the policy advisor, make sure that the changes that I'd made weren't misconstruing the meaning of what the point was. So policy advisor always check over those to make sure that what I'm saying is actually correct. Because often I'd reduce long paragraphs into sort of more plain English and sometimes can inadvertently change the meaning of what that sentence is. So this was our understanding at this point. But yeah, I acknowledge it's not very accurate.
But is it a document which generated in the line area of the department and went through the media team, or do you think that this was a document generated from earlier Q&As within the Minister's office? I guess that's what I'm asking.
Possibly. Sometimes talking points were just written by a policy advisor,
I see.
but they were all based on information that we'd had from the department.
Thank you. The media release itself from 2011 is the behind tab 16, Exhibit 4319. It, on its face, appears to an automated garnishee measure after debts have already been raised by the previous or by whatever system was in place in 2011,
Yes.
as opposed to a manual garnishee measure. But that was the document which was attached and referred to in the exchange with the Minister.
Yes.
Thank you.
Yes.
Moving then to the 7th of January. Exhibit 4320, tab 17, cth.3001.0032.6643_R. And the first email is from Mr Tudge to the Chief of Staff, Mr Aston. Subject, how Centrelink unleashed a weapon of mass destruction. He says, PM sent me this one and has the clearest critique. Please forward this to Melissa, and the link there is to an article in the Sydney Morning Herald. Does that confirm that it was the Prime Minister who forwarded this article to Mr Tudge
Yes.
about the time that the Prime Minister was asking Mr Tudge when he was returning from holidays?
Yes.
And it then makes its way to you from Mr Aston that evening.
Yes.
The article itself is at tab 18, exhibit 4321, RBD.9999.0001.0369.
Yes.
Can I take you to two passages in it just to confirm what I think you already were aware of, and that is over on the second page, 2 of 3 of the document. There are two passages. The first refers to the description of a former Centrelink worker with 30 years' experience who described how debts were raised previously, and that's in the third paragraph. And the observation of Mr Martin is in the fourth, where he notes that what was important about that description is the humans charged with applying the law didn't issue debt notices unless they had evidence that a debt existed. To do so without evidence would be to break the law. And then he goes on to describe the automated system just below the very large font at 2/3 of the way down the page. He says the formula used by Centrelink produces consistently false estimates of debts by dividing by 26 the annual wages employers report paying in order to overestimate income received during the smaller numbers of fortnights claimants get benefits. Did you know Mr Martin in terms of your professional capacity?
Yes.
This article describes him as formerly the economics editor of The Age for 4 years, a former Commonwealth Treasury official and a visiting fellow at ANU.
Yes.
Do you can see, I guess, why the Prime Minister sent the link to Mr Tudge while he was, because it was a critique of someone who might understand what was going on.
Yes. And the Prime Minister was an avid reader of the Sydney Morning Herald.
Where was the Sydney Morning Herald in your spectrum?
Left-wing media.
Left-wing media.
Yes.
What made the right wing? Not much from the sound of it.
All of the tabloids, The Australian, and some of the commercial television channels,
Okay, thank you.
Sky News.
Can I take you to tab 19? What followed, it seems, from the discussions on 7 January 2017 was that the Minister returned from holidays very soon thereafter.
Yes.
He wasn't already in the air. And had a series of meetings with members of the department who you described before over the January period while the media crisis continued.
Yes.
And during that period of time, you were copied into various emails about questions that he had, information that he had, and media issues as they were arising.
Yes.
What involvement did you have, if any, in the meetings between the Minister and the Secretary, or the Minister and the Policy Advisor, or the Minister and Deputy Secretaries?
I didn't have any involvement in those meetings.
Was it the case that you were called in, or matters were raised with you so far as they were relevant to your role as a media advisor, but not otherwise?
Yes. And I don't recall being called into any of those meetings. In fact, the first couple of days that the minister was back in Canberra, I was still on leave, which really meant working from Sydney. And I said to the minister, do you need me to come back down to Canberra as well as Mark? And he just said, no, I'll just have Mark. You can continue to, try and have a bit of a break. But in the end, it was pointless. So I just came back to Canberra. But there were quite a few days there when he was working with the department where I wasn't even in the office.
The response of the department and the minister, if you go to tab 20, to the Peter Martin article, Exhibit 4323, was to refute it out of hand, I take it.
Yes.
And that was the approach adopted based on the information from the department in respect of criticisms of the scheme throughout January.
Yes.
And your email here highlights that, I suggest.
Yes.
You advise the minister that it's important to correct the record and defend the portfolio area. And if you had a well-articulated defence and are happy to get it out in the media and defend ourselves, it'll be easier to get on top of the stories that were happening.
Yes.
And the misunderstandings that you refer to there in the fourth paragraph, again, despite what you might have thought personally, is that a reference to what the department was saying was the true position?
Sorry, that was the fourth paragraph?
Yes, most of the criticism
Yes.
centres around a misunderstanding of how the system
Yes.
works.
That was my understanding at the time,
Right.
was that people were receiving jet notices because they were not meeting their mutual obligations, or that they were misunderstanding the system. And yes, that's right, sorry.
No, that's okay. And again, the minister responds, thanks, Rachelle, that's discussed today.
Yes.
What was attached to that email, if we just go over to the page 0812 and following, is Ms Bland's attachment of all of the links to the adverse media over the past period of time.
Yes.
It seems Boxing Day, the 28th of December through to the 8th of January.
Yes.
And that reflects the crisis that existed in the media at the time.
Yes.
You referred earlier to Mr Tudge clearing all the lines
Yes.
of material attributed to him.
Yes.
If you turn to tab 21, Exhibit 4324, you'll see an email from Mr Aston to yourself, copying in, of course, Mr Tudge, Mr Wood and your assistant, Ms Bland, which refers to a starting point that Alan has dictated. That's Mr Tudge.
Yes.
And again, it indicates his the extent to which he was involved in the media as you described.
Oh, yeah, yeah. He was intimately involved in the media. Yeah.
Right.
That's not unusual for him. It was very regular for him to do that type of thing.
And if you go to the next page, Exhibit 4325, CTH.3108.0003.5563_R, you'll recall from one of your earlier emails you were drafting an op-ed after being infuriated about the articles while you were on leave. And, sorry, tab 22.
Yes.
Mr Tudge came back with some comments of his that he didn't think it was strong enough.
Yes.
Okay. And can I just get you to confirm that behind tab 23 was the draft of the op-ed as it existed at that point, Exhibit 4326.
Yes.
Thank you.
My op-eds were never, ever good enough.
You referred earlier to the relationship between Mr Tudge and Mr Porter
Yes.
in respect of media matters and the consultation that existed
Yes.
between them and between their respective media advisors, yourself and Mr Donnellan.
Yes.
Can I take you to tab 27? This is an email sent by you to Mr Tudge Friday 13 January, which contains a reference to Minister Porter's feedback on a draft media release.
Yes.
And it comes through Mr Donnellan to you. Again, is that exchange there a reflection of what it seems to be a cooperative approach between Mr Porter and Mr Tudge?
Yes, exactly. Minister Tudge was very cautious about doing anything that might offend Minister Porter, but at the same time he was often reluctant to let Minister Porter take all of the media glory.
Okay.
So they did have a kind of a good balance. And I mean, Alan would regularly text Minister Porter and sort of say, hey, you okay with me doing this? And often, you know, if you looked at the strict kind of boundaries that usually existed between senior ministers and junior ministers, a lot of senior ministers would be like, no, I will do that. But Alan, I think, in my judgment, got a fair bit of leeway with Minister Porter. And this is very typical of the type of exchange that we would have to approve things with Minister Porter's office and Minister Porter himself.
Can I take you to Exhibit 4332, tab 29? The heading is Minister Tweet Update Media Plan, and the date's 18 January 2017.
Yes.
The passage that I wanted to draw to your attention is the email from Mr Hannan to Ms Golightly, Ms Campbell and others, at the bottom of the page, which refers to the likely approach from the Minister's office over the next week.
Yes.
And again, we understand that's generally a reference to advisors or media, either policy or media.
Yes.
But there is a specific reference to the media advisors' thinking.
Yes.
You can see that? Mm-hmm. And there are a series of dot points. The first relates to a Senate inquiry. The Minister's office is working with crossbenchers to provide them with facts prior to voting on any motion to establish an inquiry.
Yes.
Was there an understanding in the Minister's office that a possible Senate inquiry into the Robodebt scheme was less than ideal?
Yes.
And that reflects attempts that might be made to cut that off at the pass.
Yes.
The third dot point refers to News Corp. That's not
Yes.
the left-leaning media.
News Corp is right-leaning media.
They're not interested in the line being run by left-leaning media, but are keen on the alternative view, and that you
Yes.
work with them to achieve that.
Yes.
And there were other factual matters which you were identified as being provided by Melissa's group. That's Ms Golightly's group,
Yes.
Deputy Secretary responsible for the implementation of the scheme.
Yes.
Okay. Would you describe the work of the Minister's office together with the department in January 2017 as involving a comprehensive and coordinated defence of the scheme so that it might continue,
Yes.
irrespective of the nature and extent of the criticism?
absolutely.
Did anybody think about the legal aspect of it? Was there ever any inquiry that you heard about into whether there was any legal advice to say that it was okay?
Not that I recall.
Okay, thanks.
Although I did note, looking at Peter Martin's article there, that he pretty clearly stated that it was illegal in
Anyway,
January.
that didn't seem to be at the forefront of anybody's mind so far as you were concerned.
No, no. Basically, because I expect that if a media release on a policy area has been cleared by the department about a policy that's ready to go, that it's well and truly well past the legaling stage.
Fair enough.
There are two further topics I wish to take up with you by reference to the documents, Ms Miller. The first is another media article that was run in The Australian on, I think, 26 January, Australia Day.
Yes.
You can see it behind tab 69 in your bundle. It is Exhibit 4371, CTH.3007.0005.6573.
Yes.
You seem to have some recognition of the article.
Yes.
What can you say about it?
That was an article that we liked.
And if you go back to tab 67, it's not necessary for the screen to go to any other exhibit. There are emails exchanged involving case studies and lines sent to Simon Benson from The Australian today.
Yes.
It's got lines attributable to Minister Tudge, stats provided.
Yes. Yes.
Oh, it's up on the screen.
Oh, yep. Yep.
Case studies,
Yep.
and it runs for many pages. And you'll see a cleaner version of the document behind tab 68, Exhibit 4370. Again, this was what you described as part of the media strategy in an
Yes.
effort to engage with a journalist who were prepared to present an alternative view,
Yes.
where you worked with them and provided them with the information which would enable the story
Yes. Yes.
to be written in a way that the minister liked,
Yes.
or at least presented in a way that the minister liked.
Yes. And Simon Benson was very good at doing that.
Sorry, I said there were two topics, there are three. The second is the minister's involvement with representatives from ACOS,
Yes.
the Australian Council of Social Services. Do you recall Dr Goldie and
Yes.
Ms Crowe attending the minister's office for a meeting in January 2017?
Yes.
What do you recall of that meeting?
I only recall that they attended a meeting in the minister's office. I wasn't in that meeting, but I later spoke to the minister about the meeting, or he told me about the meeting, and said that they had agreed that none of the contents of the meeting would be made available to the media. And then he got really annoyed when I showed him maybe a few hours later that it was all detailed in The Guardian, I think. So he was very frustrated because he was like, well, you know, I said that I wasn't going to release anything to media and I shouldn't have really trusted that they weren't going to either. That's from my recollection.
Right. I can take you to three letters behind tabs 113, 114 and 115. I think they are out of chronological sequence. The first in time is Exhibit 3103, tab 114, ACS.9999.0001.0177, a letter from ACOS 21 December 2016.
Yes.
Do you recall before Minister Tudge went on leave in December 2016 that this letter was... Oh, Exhibit 3013. Thank you. Do you recall that before Mr Tudge went on leave in December 2016 that this letter was received by the office?
I don't.
No. And if I can take you to 3065, Exhibit 3065 behind tab 115, ACS.9999.0001.0230. It's a letter 19 January 2017.
Yes.
Which refers to a meeting the previous day. Can I just, were you aware of this letter coming into the office?
Not that I recall.
Not that you recall. Can I take you to the second page of the letter? It says, in light of the further very serious allegations released by GetUp today, and it continues, and it refers to a Centrelink whistleblower. Do you recall there being an article in GetUp today relating to a whistleblower and union staff, CPSU staff?
No, I don't recall that, but it wouldn't be something that would have surprised me. Yes. And we tended not to notice or spend much time on anything that GetUp said.
And irrespective, I take it even though you weren't aware of the letters from ACOS, you understood that they were
engaging with the minister. Yes, definitely. Yes.
In a way which sought the halting or changing of the scheme.
Yes, and it would be normal for ACOS to put that in writing because often, they'd put a letter to the minister in writing and release it to the media at the same time. And that was a common strategy for a lot of advocacy groups or industry bodies. Just helps them gain media attention about and highlight the issues that they have.
Okay. Can I take you to tab 101? This is the third topic. It relates to the report of the Ombudsman. Exhibit 4399, CTH.3098.0011.4478_R.
Yes.
It's your email to Mr Hannan, Tuesday 4 April 2017, and it refers to the latest draft report and asks him to focus on the points you've identified from the draft report for immediate release.
Yes.
What do you recall of the content of the drafts of the Ombudsman's report which you had access to in terms of...
I don't recall a lot. I mean, I would have scanned over it to look for the points that would suit the narrative that we were pursuing. And as you can see, I've pulled those out and they're the substance of what we wanted to say to the media. Beyond that, focus on perhaps some of the criticisms and things would have been what my policy advisor would have focused on with the department to ensure that those things were fixed. And in fact, you can see here that we commonly like to be able to say that, we saw these things from the draft report, and by the time the final report comes out, we can actually say, well, most of those recommendations have already been implemented. And I've done that multiple times across multiple ministers' offices.
Okay. Can I ask you to go to tab 102, Exhibit 4400, CTH.3051.0017.7589_R.
Yes.
This is an email from Mr Tudge to you the following day. The attachment is Ombudsman press release. Rachelle, Andrew, Mark, so all three of you
Yes.
are recipients of the letter.
Yes.
The attachment is at tab 103, exhibit 4401, cth.3051.0017.7590_R. And if you peruse that document 4401, you can see that there is a very positive response, I suggest, to the Ombudsman's report.
Yes.
And that appears to be the impression gained by Mr Tudge about those particular passages.
Yes. Yep, that would reflect exactly what he was thinking.
That is, that he thought the report was quite powerful, to use his words in.
Yes, well, powerful in terms of being able to give him a strong defence of the system.
And do you recall that the report was relied on in its final form to provide that strong defence to the system?
Yes. In its final form.
In its final form, yes. Commissioner, that covers the topics for my examination.
Ms Hogan-Dora?
I have no questions for the witness. Thank you, Commissioner.
Mr Goh?
If the Commissioner pleases. Ms Miller, Mr Gregory asked you about an article published in The Australian by Sarah Martin, the 5th of December article. Do you remember that?
Yes.
For the Commission's benefit, that was Exhibit 4313. Mr Gregory asked you about some of the quotes that were attributed to Minister Tudge,
Yes.
and your answer was that he always cleared those lines attributed to him. Do you remember?
Yes. Yes.
What about content that was given to journalists that was not in the category of a quote attributed to Mr Tudge? Was that also cleared by him?
Yes.
Mr
Do you
Gregory,
ever do anything off your own bat in that line?
No. Not with Mr Tudge.
Mr Gregory also asked you some questions about Mr Calzo before lunch.
Yes.
And he took you to an email from the department to you dated 16 February 2017, where the department was bringing it to your attention.
Yes.
Can the witness be shown Exhibit 4410, which is CTH.3108.0004.1917_R? Can I ask you, Ms Miller, just to take note of the date there, 21 February 2017? Now, if you could go down to the first email in that chain, that's from Mr Tudge to you, correct?
Yes.
And it's just a simple question of you.
Yep.
And so he asks, what are the lines? Re mental health and debt. And then there's a response from you, and you clarify ultimately that response right at the top, temporary waiver from repaying the debt.
Yes. Yes.
So am I right in understanding that that is you saying to the minister, well, here is one thing that you can say in relation to mental health and debt that they could?
Yes. As long as that person had actually let the department know of their mental illness.
Thank you, Ms Miller. So just bearing in mind that date of 21 February 2017,
Yes.
I won't take you to the document, but you recall Mr Gregory asking you about an email you wrote in which you described the Saturday papers reporting as, quote, disgraceful?
Yes.
And that email from you, if you can take it from me, was on the 26th of February.
Yes.
So 5 days after what you just saw on the screen.
Yes.
Is what you just saw on the screen, that is, here is a way in which someone who does have a mental health issue can get some leeway.
Yes.
One of those things that fell into the category of...
Misleading reporting. Yes. Yes.
Thank you, Ms Miller. Before the lunch break, Mr Gregory asked you about the media plan, which you described in your statement with those 4 dot points as part of the crisis strategy.
Well, that was outlining the narrative that we were focusing on achieving, and there were various ways in which we were going to achieve that
Yes.
outlined in my submission.
So those 4 dot points, and for the benefit of the Commission, this is on page 7 of Ms Miller's statement. Those 4 dot points as part of that strategy,
Yes.
was that subject of anyone's approval in the Minister's office?
The Minister's approval.
And then when things went into crisis mode,
Yes.
was the crisis strategy subject of anyone's approval in the office?
Yes, the Minister. And the Policy Advisor and the Chief of Staff.
And Mr Gregory also asked you some questions about the release of personal information of some Centrelink customers.
Yes.
And one of the things you said in your evidence before lunch was that the strategy of putting out personal information to shut down personal stories was a successful strategy.
Yes.
And again, who was responsible for approving that as a strategy?
The Minister.
No further questions, Commissioner?
Okay, Mr Goh, I've seen your application for leave to cross-examine tomorrow.
Yes.
My provisional view is that you should have it. I'll wait to hear if there's any compelling argument to be put on behalf of Mr Tudge to the contrary, but presently I can't see why you shouldn't have leave to cross-examine for the limited purpose you identify.
If the Commissioner pleases.
Mr Gregory?
Might Ms Miller be excused?
Yes, thanks, Ms Miller. That's been very illuminating. You're excused. We might take that 5-minute break I spoke about.
Thank you, Commissioner.
All rise. The Commission stands adjourned for a short break. Royal Commission is now in session. Please be seated.
Yes, Mr Gregory.
Thank you, Commissioner. One matter of housekeeping. In the exhibits I tendered earlier, I tendered Exhibit 4535 as part of that group. There is a claim of public interest immunity over that document, and I withdraw it from tender at this stage, but it falls into the same category of documents over which claims were made for the witness, Mr Carter, last Friday. It is a claim which is the subject of discussion between the AGS and the solicitors assisting the Commission. But for the time being, I think I grouped it in with everything else. 4535.
All right, so we don't have a 4535 for the time being.
For the time being, yes.
Thank you.
Thank you. Commissioner, the next witness is Mr Hank Jongen.
Mr Jongen, will you take an oath or an affirmation?
An affirmation, thank you.
Okay, would you stand? That will be administered.
Your response is, I do. Do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Yes, Mr Gregory.
Thank you, Commissioner. Mr Jongen, you're employed with the Department of Human Services or Services Australia,
Services Australia.
and you have been employed with Services Australia or its predecessors of varying titles, I think, since the 4th of April 1973.
That's correct.
You have had various roles, but a number of them over the last decade have related to media.
Yes, that's correct.
And although they have varying titles, you are often described as the spokesperson for the department.
That's correct.
You had a significant role to play in respect of the compliance and debt recovery scheme, which has been described as the Robodebt scheme.
That's correct.
In your position, you were assigned a range of media roles, that is, speaking roles, and you were attributed to, or various statements were attributed to you as the spokesperson for the department.
That's correct, as is normal practice across a range of programs across the organisation.
Your role, I think, historically has involved media budgets and the like.
Media.
Budgets.
As the General Manager Communication, yes, I would have been involved in budgetary issues at that point, yes. But in my role as agency spokesperson, it's a much more restricted role without any budgetary or management responsibilities.
The reason I raise budgets is because there is at least an understanding within the department that time in the media can be assigned a dollar figure.
Yes, that was, I guess the best way to describe that is that it was a fairly rough and ready indicator that was used to measure the amount the amount of media that specifically I generated, and it was a pretty rough and ready way of measuring that performance. Since then, we put in place much more sophisticated approaches of evaluating the nature of media and the effectiveness of the way in which that media is presented.
And I should have indicated for completeness in your previous role, that was, I think, at an SES level 2 position.
That's correct.
And you came back to the spokesperson role, I think, on a part-time basis.
That's correct.
3 days a week?
Generally, although, as you can appreciate, it's a media role, you need to be flexible on the 3 days a week.
Right. The extent of your involvement is reflected in an email perhaps tongue-in-cheek, which is Exhibit 1874. Do you have the folder there in front of you with your name on it?
Yes, I do.
That's it. Could I ask you to turn to tab 103, as I've said, Exhibit 1874, CTH.3004.0002.8252. This captures at least the summary provided by Kathy Sear, Acting General Manager, Community Engagement Division, of the work that you had done in respect of your media role in January 2017. Can you see that?
This is the email from Kathy Sear to Catherine Campbell.
That's right, yes. The date of it is 20 February 2017. And it commences, "Hi Catherine, I thought you'd be interested in a media wrap-up from January 2017.
Are we just interested in the bit about Mr. Jongen?
Yes. You can see that there was a total volume of media coverage. I think we've captured it all. But if we just go down a little bit, there was over 10,000 media items, 61% were negative, 39% were favourable or neutral. There was, as you say, a rough and ready figure ascribed to the equivalent advertising spend of about $7 million, and you featured in more than 500 media items worth $1.8 million by that rough and ready measure. 30 original broadcast interviews syndicated more than 300 times 30 original print items, and you're ascribed as or attributed as successfully neutralising 133 items, many of which were high impact, key national TV, radio and print media items. You weren't the author of that document, I understand, of course, Mr. Jongen, but as the media spokesperson for the department, dealing with negative media was a central part of your role.
Yes.
And dealing with it meant neutralising the criticism for the reputation of the department.
That's part of my role, yes.
Responding to the content of it where you can.
Yep.
And emphasising positive aspects which might not have been emphasised in negative media articles.
Yes.
Undoubtedly, January 2017 was a busy time for you, given the media attention to the online compliance intervention program at that time.
Yes, but simultaneously, I was also dealing with another government initiative, and it related to changes to the pensions assets test. Now, as a result of those changes, some pensioners were going to receive reductions in their rate of payment. Other pensioners were receiving an increase. Most pensioners would not be affected. Now, the age pension population is perhaps the most volatile group of customers that we need to deal with. It's very easy if you don't explain change carefully and methodically.
Mr. Jongen, this may be too much information because I don't think... what you're saying is that you had a lot to deal with, are you?
Yes. Apologies. Yes, that's the case.
All right, thank you.
In terms of a cohort, I'm just taking you up on your explanation, pensioners, you say are volatile. Is that because they can exert a strong public voice?
No, it's more to do with you can create concern within that population if they don't understand that they're not affected by the changes.
What about the Robodebt scheme then? Surely you had a vulnerable population who was exhibiting an enormous amount of concern in January 2017.
Yes, that was also the case.
certainly from a media point of view, you would describe the circumstances surrounding the attention to the scheme as volatile
Yes.
at that point in time. You say in paragraph 48, when you are dealing with your role as a media spokesperson, and I should say, of course, Mr. Jongen, you were served with a notice to give a statement and produce evidence in final form dated 20 October 2022, and you produced your statement in response dated 14 November 2022. I see you're nodding, but it's being recorded, so you'll just have to give a verbal response.
Yes, yes,
And the contents of your statement are true and correct to the best of your knowledge
yes.
and belief. Thank you. I was taking you to paragraph 48 of your statement, Exhibit 4412. In your response to questions, it's page 14 of the document, in your response to questions, you set out the nature of your role as a spokesperson, and you identify that you had very limited involvement in the preparation of media releases and did not ordinarily provide information, instructions, directions and advice to the persons in the categories you've identified there.
Yes.
You also say at paragraph 48 in the emphasised passage that the process for approval of media material in relation to Robodebt was the usual process, but the hierarchy for approval of media materials was strictly observed when Melissa Golightly was the Deputy Secretary, because she insisted everything be cleared through her.
Yes, that's correct.
Is that just media from the department, or is that what is forwarded to the Minister's office for the Minister's office to release through the Minister?
I can't really answer that question because I was not involved in any of the liaison with the Minister's office.
Okay. You say at paragraph 49 that you were conscious to remain politically neutral and that your focus was on factual information in the best interests of the customer. I appreciate that's a general statement about the nature of your role and the way in which you conduct yourself. But at paragraph 54 at the bottom of the page, you indicate that as far as possible you tried to avoid the topic of the Robodebt scheme because it was increasingly political and issues of political significance made your job more difficult. And you refer again to your general approach of endeavouring to provide factual-based media statements. Was it the case that when an issue was politicised, such as the Robodebt scheme, there was the potential for a conflict between the politics of the policy and the facts that might be in the factual information that it was in the best interest of the customer?
Yes. The first observation I'd like to make, if I may, is what I was trying to capture there is not the environment in the early stages of January 2017. What I was trying to capture there was that, dissent and anxiety about the program evolved over a period of time, and further down the track, maybe a year or two further down the track, as I became aware of a court case which would prove to be significant, and then when the government decided to discontinue the Robodebt scheme, it was at that point that I felt that this was primarily the responsibility of a minister, because what we were talking about here was getting into the area of government policy. So what I was trying to capture there is that evolution over time rather than the environment in January 2017. If I may reflect on my attitude in January 2017, once I became aware of the significance of what that program meant, which was an escalation from 20,000 cases a year to 20,000 cases a fortnight, my immediate reaction was, what this indicates is that clearly there are tens of thousands of people that have under-declared or not declared their earnings. My other reaction was, once I was briefed and understood the principle of averaging, I knew from my past experience that on occasions averaging had been used. So in my mind, there was a legitimacy. But what I realised was that it was not my role to promote this program, that my role, as I've always tried to do as agency spokesman, was a customer service role. And what I resolved to do in discussions with the media team was to ensure that customers understood what this program meant. The first thing, and my messaging became crystal clear, the first thing I sought to do whenever talking about this program was explaining that the letters that people received were not a debt letter. They highlighted a discrepancy. The second thing that I felt was important was that people should not ignore the letter because it would just lead to further difficulties. And then, of course, I was promoting the fact that there were ways to resolve the discrepancy that had been highlighted. And I felt that it was really important in that customer advocacy role to focus on those elements rather than justifying the program.
You referred in your answer to an awareness of averaging once you became acquainted with the concept in the context of the Robodebt scheme. Can I ask you to elaborate on your awareness of averaging from your previous experience in the department?
Certainly. Look, as you've indicated, I have extensive experience in the department. And many, many years ago, I was involved in a role as a pensioner assessor. And as part of my training in relation to, raising debts, etc., I specifically recalled that as a last resort, averaging could be used. And in fact, I've been thinking about it. It is quite possible that at some point I may have actually used averaging, although I can't specify that was.
Can I just ask you, what was the income test, though, for pensions? Wasn't it an annual rate of income?
Yes, it was, yeah. And
Okay, different test, isn't it?
sorry, I referred to pensioners, but of course there are other benefit payment types. And thank you for enabling me to clarify that, because again, my training was much broader than pensions, and it would have applied to, in those days, payments like, I think it was called New Start or unemployment benefit at that stage.
I take it from your awareness of the concept, but your inability to specifically recall applying averaging, that the understanding in the department was that if it was used, it was rarely used.
Yes.
And that was because there were better ways of establishing a person's annual or fortnightly income.
Absolutely.
Yes.
And I think the point I made is that I was broadly aware of the concept of averaging.
Yes. When you became familiar with what was involved in the Robodebt scheme, did it appear to you, from your knowledge of the rare use of averaging previously, that this indicated a real difference to the way in which averaging was applied? Yes. While you observe, as you say, a customer-centric role where you emphasise the first letter is not a debt letter, it's a discrepancy, did you descend into the detail of the information contained in the first letter?
No, I didn't. In order to be effective in terms of explaining change to customers, it means that I have to use simple language and try and keep the messaging as concise as possible.
Were you aware that the discrepancy letters didn't identify the extent of the discrepancy? They merely referred to the PAYG information summary and not what had been reported to Centrelink?
Yes, and I was concerned about that.
Do you recall taking those concerns up with anyone?
Yes, I did.
And who was that?
The first thing I have to say, of course, is that at that time, it was not my responsibility to engage with the business line. However, I took the opportunity of I bumped into Melissa Golightly in a corridor, and I took the opportunity because I thought it would be useful in a friendly way to engage her in a discussion. And I outlined to her a number of concerns that I had. I told her that I thought the letter was bad. I asked whether it had been focus tested. By that I mean tested with groups of customers to see whether they understood it. I was concerned that it didn't have a call to action in the form of a phone number, which I thought was decidedly unhelpful. In addition to that, I'd also asked to be shown how the system worked because I felt it was, this is not uncommon for me, I felt I needed to understand what the customer experience was. And once I went into the system, I found it was incredibly difficult to find the button that enabled you to start to resolve the problem. So I raised these concerns with Ms. Golightly, and it ended up a very heated and aggressive discussion where she told me, firstly, that the program had been pilot tested. Secondly, that this was business as usual. And thirdly, that basically it was none of my business.
Of course, even if your change of role from your former position, and I can't immediately recall the description of it, to the departmental spokesperson meant a part-time role, you had, as you've indicated, a long serving career with DHS at a very high level. Following that exchange with Ms. Golightly, did you consider whether you should take it further, that is, raise it with the Secretary?
I decided not to.
Yes.
If
you might explain.
For a couple of reasons. Firstly, I was aware that there were other people within the organisation with specific responsibilities that were now starting to look at that. The other thing I became aware of within a matter of days actually was that those very issues were starting to be highlighted across the organisation and that in fact remedial actions were starting to be taken. And so I guess in a sense that satisfied me that some progress was being made in terms of the communication to customers.
The second stage of the information that you emphasised was communicated by you in terms of your customer focus was that it was very important to respond to the discrepancy letter because otherwise further difficulties arise. And by that I take it you understood that in the absence of a response, averaging of PAYG data was used to create a debt.
That's correct.
And that averaging in those circumstances concerned here with income support supplements assessed on a fortnightly basis was likely to lead to inaccuracies as a result of that averaged process.
Certainly I understood the potential.
Yes. You're right.
If I may, the other thing I then did, because I felt I believe that I'm a trusted representative of the organisation, and I take great care in ensuring that I can reflect the customer experience. So another thing that I did early in the piece was I actually went to the call centre that dealt with the inquiries that were coming in as a result of these Robodebt letters. And I went through a process that's called dual head setting, where I listened in on callers that were ringing. And there was one particular caller, a woman that was a trainee teacher. Not a trainee teacher, a part-time teacher. And she had advised us in a previous call that she was only paid during the semesters and not paid during the school holidays. So she had been advised, well, if you can get back to us with details of your school holidays, we can have a look at your case. Now, as it turned out, I listened in on that particular call. She provided the dates, and the dates were entered, and it ended up in a zero overpayment. That had the effect of reaffirming in my mind how important it was for customers to seek to resolve the issue. The other thing that happened was that in talking to the staff at that call centre, it became obvious to me that their training was geared towards doing everything they could to help the customer resolve their situation, regardless of whether it cancelled the debt or clearly established whether there was a debt.
For people who fall into the category of a part-time teacher, who probably sounded articulate and informed about her personal circumstances and well organised, you can see how a response was able to be made in a coherent way which solved the potential for a false debt to be raised. But of course, I take it from what you've described as your extensive experience with the department that many people who received these letters would not fall into that category.
That's correct. And under those circumstances, what I would always say was call us. We understand that you may not be computer literate, call us, talk to us. Because I felt that through engagement, we could help people resolve their situation. And I felt that was my primary responsibility in relation to Robodebt.
The media statements that were attributed to you fall into, I think, three categories. Ones which are attributed to you but which you had no involvement, ones which are attributed to you which you might have had some involvement, and ones which you were more actively involved in. And you've identified those in the comprehensive table attached to your statement. The questions which were raised in the media were not just about process for the recipient, though. They concerned underlying questions of fairness and legality about the way in which debts were being raised. Where you were involved in, that is, to some degree, in statements attributed to you which asserted that the scheme was fair and it was lawful, did you go behind what was attributed in those statements, or did you just, or were you content to adopt the departmental line?
No, sorry. In terms of adopting the departmental line, it wasn't a question of it being a line. It was expert advice that I was given that the scheme was legal. Not that I applied myself to the legality to any great extent, because I'd accepted from the beginning that it was legal and legitimate. In my own mind, I certainly had some issues in relation to the morality of it. But having said that, you could argue that in relation to a number of policy that we have to apply.
The expert advice, about the legality. Where did that come from?
It came from two levels. Bearing in mind that every statement attributed to me had been signed off by legal counsel and, in addition to that, by the responsible Deputy Secretary. So from my perspective, that was the expert advice that I relied on.
There were occasions, I take it also, where it was clear to you, if not on the document, from your understanding of the relationship between Ms Campbell and Ms Golightly, that the Secretary was also involved in some occasions on clearing the media message.
Yes.
Do you recall in January 2017 there were media stories on the 19th of January which raised or which attributed various statements of facts to a whistleblower, which was published on Get Up Today, I think supported by the CPSU, and that there was a very strong response from the department to those allegations.
Yes, that's correct.
Do you recall Ms Campbell being involved at that point?
What I do recall is being told by a media officer that the Secretary had agreed to this response.
Yes. Was it apparent to you at that point that the department was facing criticism both externally from customers and journalists, but also internally from whistleblowers whose criticisms were coming through the external media?
Yes.
Do you recall the department's response to be very clear to persons within the department that they really should keep their concerns in-house and go through the usual public interest disclosure channels?
I don't recall, but it wouldn't surprise me.
I might not be able to turn it up quickly, but I may not. The questions of your concerns about ethics, I think you've identified the basis of it in your evidence.
I think my words were, I worried about the morality.
Sorry, you're worried about the morality of it. And the basis of your concern about the morality of the system is the vulnerability of a large cohort of recipients,
Yes,
the difficulties they might face in an online environment,
yes,
the initial rollout of the scheme, which didn't have very obvious measures that assisted anyone to engage with it, either by telephone or online.
yes,
And the question you had in your mind about the role played by averaging, which was being applied on a much greater scale than in your awareness of it historically.
yes,
And the potential for the raising of debts which weren't in fact owed.
that's correct.
And it seems that the telephone call that you listened to confirmed in a positive sense, where people were able to engage, that the scheme was navigable, but probably confirmed that the potential for debts which didn't exist was very real in terms of the use of averaging.
Well, that was certainly what was being put to me on a regular basis through media and other avenues.
And it seems that the part-time teacher was a clear example where the averaging process created a debt which didn't, or alleged a debt which didn't exist.
Yes, that's correct.
Do you recall, again with your unique knowledge of the role played by averaging or your awareness of averaging historically, and your understanding of the role played by averaging under the Robodebt scheme, that there appeared to be a tendency in departmental media releases, either ones attributed to you or not, to diminish the critical point about how debts would be calculated by resort to averaging if people did not engage.
I can't say that that was my perception at the time. I simply can't recall. We're talking a fair while ago now.
I appreciate that. Put more succinctly, there was the emphasis upon the fact that the first letter was not a debt letter but a discrepancy letter, that it was very important to engage, and if you engaged, you would be able to ascertain the true position.
Yes.
Rather than the intervening step that if you did not engage, averaging would be applied.
Correct.
That is, those three areas of emphasis did not include the averaging step.
That's correct, yes.
Would you agree with me that the averaging step was the one of critical significance as the reason why people should engage?
Yes.
Did you use that departmental line? That seems to have been common in some contexts of the methodology hasn't changed.
I can't recall specifically making references to that. I have to say that my overwhelming desire was to ensure that customers avoided getting themselves into trouble by engaging. And the messaging evolved even more strongly. Bearing in mind my written briefs could differ to what I actually said, because it's a question of how you tailor the message.
Because you must have had a fair idea that the use of averaging had certainly changed. It had now become a default position if there weren't a response.
That's true.
Thank you, Commissioner. Mr. Jongen, I've located the document about whistleblowers. Can I take you to tab 55 in the large bundle? It's exhibit 4463. CTH.3001.0039.5424. The document is described as consolidated talking points, and the date at the bottom is 21 March 2017. It is 38 pages in total, and there are various versions of the document which are listed there. The last is version 13, bearing the same date, and attributed to Andrea Cole. Do you recall what position Ms. Cole held?
Yes, Andrea was a media officer, to the best of my recollection.
Thank you. The index on the page .5425, 2 of 38, sets out a large number of topics. Was this document the central reference point which was developed over time as issues arose and the department reached a position which could be published externally?
Yes.
So as at 21 March 2017, it would have been progressively updated to reflect statements previously made or new positions adopted.
That's correct.
It didn't necessarily reflect everything that was a live issue in the media that week.
No, that's correct.
The point of whistleblowers is dealt with at page 36 of 38 and 37 of 38, dot 5459 and dot 5460. The document's presented in a question and answer format that was typical of the way in which material was developed and presented for you.
Yes, that's correct.
Do you recall being provided with this document or earlier versions of it?
Yes, I do.
Thank you. 6.123.1.23 is the heading whistleblowers. The first question is, what do you say about the whistleblower claims? And there are 5 subparagraphs there. The second question is on the next page, why are you threatening whistleblowers with sanctions? That's the particular point I wish to take you to. On 37 of 38, there was, to your recollection, statements by the Secretary, I take it, which indicated that if departmental officers spoke externally about confidential information, that gave rise to some potential issues for them, in broad terms. Again, I know that you're nodding, but it's being recorded.
Oh, yes,
Thank you,
yes. My apologies.
And what was set out in the dot points there was a number of justifications for the message communicated by the Secretary to staff. The fourth of which related to the importance of observing the privacy provisions or the privacy of Centrelink information and the relationship between the privacy provisions and potential criminal offences and the code of conduct or breaches of the code of conduct. The sixth, justified the Secretary's statement as part of broader learning and development commitment to staff on a wide range of topics, including values and culture, family and domestic violence, cultural awareness, fraud control and service delivery. Did it appear to you that the approach taken by the Secretary could easily fall within any one of those categories of information there?
I'm sorry, I'm not sure I understand the question.
The justification for the Secretary's message to employees identifying potential sanctions for whistleblowers doesn't seem to fit easily within our values and culture, family and domestic violence, cultural awareness, fraud control and service delivery, does it?
No.
No. Okay. Did you perceive that the statements by the Secretary in respect of potential sanctions for whistleblowers reflected an intention to reduce criticism of the scheme from within?
Yes.
There is a further document.
Can I just also make one other comment?
Of course.
And that is that whilst these briefing notes were prepared for me, and they did represent the culture within the organisation at the time, I've never used these notes in a public sense.
These were prepared in anticipation of potential issues which might arise in a live interview that you might be involved in.
Yes.
Can I take you to tab 53, Exhibit 4461, CTH.3010.0008.0049. It is an example of a particular document, and I wish to ask you some questions about it. It is described as a media forward plan, August 2017, with a critical date. The reason is to progress with planned media activities, and it is a minute in the form of a minute addressed to the Secretary. You can see that?
Yes.
And what is attached to it is a table which is for approval, attachment A, which identifies dates, programs, descriptions of potential media opportunities which have been identified in advance.
Yes.
These are, and if we go to page 0051, that's the first page of attachment A. These are media opportunities identified by the media team, which have some direct relevance to you potentially in your role.
Yes.
And the process within the department was that the Secretary would approve the proposed broadcast media interview commitments and general media opportunities set out in the monthly plan.
Yes.
And they would be approved by her ahead of time.
Yes.
All right. And that reflected that within the hierarchy of the department, a particular process established by the Secretary where she personally approved the media opportunities.
That's correct.
In this sense. If we go back to page 0049, it's language I'm unfamiliar with and you might be able to explain it. You can see under the heading Issues, there are 4 paragraphs. The third says this will ensure there is rolling public messaging to prepare the community for the new and increased compliance activity occurring this financial year, consistent with the department's commitment to adopt citizen-centric tactics so external stakeholders are properly engaged throughout change initiatives.
You translate?
Yes, thank you.
I have to say, I'm a bit bemused by these words as well. My interpretation goes back to, in considering the date. Look, let me just make the point. I did not write this document.
Yes.
And to the best of my knowledge, I don't believe I've seen the document before. And I don't want to reflect further on that.
Thank you.
Did you have much to do with the Chief Citizen Experience Officer?
No, I didn't.
Were there lots of citizen experience officers? Why was this one chief?
I can't answer that question, I'm sorry.
Perhaps somebody will sometime.
Well, I note that the Secretary did make a comment.
Mr. Jongen, could you please turn to tab 66, Exhibit 4474, CTH.3010.0010.3477. Mr. Jongen, you'll recall that the scheme came under increasing criticism externally in respect of its legality in 2018. And at the bottom of the page, there is a reference to an article by Professor Terry Carney in the Alternative Law Journal, and it sets out a summary of it there. And if you go over to the next page, 3478, more is said there, and questions are asked by Mr. Nouse from The Guardian, and they are, what is DHS' response to the claims that the OCI operates unlawfully as a form of extortion? And it continues. He raises the third question, one of ethics and model litigant processes, and whether DHS accepts that criticism. The response was circulated from the media team to Mr. Taylor and Mr. Wanke, copied to Ms. Sear, Mr. Hannan and yourself. It refers, of course, to the previous claims from Professor Carney, which you may recall were published in approximately April the same year, yes. And Mr. Taylor's response, who is the senior media advisor to Mr. Michael Keenan, proposed that the response cleared for ACA recently about the Melbourne QC who was threatening legal action be recycled. We turn to dot 3477. You can see that?
Yes.
Yes, if that passage can be pulled back and we go to the first page of the email, thank you. In the face of increasing external criticism of the legality, the now 2 articles from Professor Carney, and there was a current affair report on a Melbourne QC threatening a class action. Do you recall that there was any sense within the department that there really ought to be a close review of the legality at this point?
No, in fact, quite the reverse. If you look at the way in which we responded at the time, you will see that, I can't remember the exact words, but there is a response there where I talk, where I'm attributed to saying that the criticisms are incorrect and
I'll just take
we
you to
detail those.
Mr. Jongen, so that you don't have to do it from memory. Tab 70, Exhibit 4478.
Tab 70.
Yes. CTH.3735.0001.0368. This is the response, I think, which is attributed to you.
That's correct.
Yes.
Yes, that's what I was referring to. And as you can see from this document, it clearly states that it doesn't question the legality. It talks about the fact that, you know, what we're not talking about, well, look, the statement speaks for itself. And the effect that that had on me was it simply reaffirmed the issue of the legality of the scheme. And to the best of my recollection, I can't recall having any actual discussions about the legality at that point.
That is, this fell into the category of responses to which you were copied, developed by the media team and attributed to you.
That's right. But again, endorsed by the business line at the Deputy Secretary level.
Yes. And does it follow from your evidence that you can't recall any discussions about it, that these external criticisms of legality were quickly dismissed?
I can't really recall any detailed discussion about legalities.
The last document, Mr. Jongen, is behind tab 39. It is exhibit 4448, 4448, CTH.3735.0001.0141. This is in the early days of the media crisis, Tuesday, 10 January 2017, a response attributed to you. And it was an example of a response attributed to you where there was a statement asserting there's no change to how income is assessed or how debts are calculated in the second last paragraph. I appreciate you dealt with a lot of media statements, responses and interviews. Do you recall this was a line which was, or a position, not a line, a position adopted by the department in its public response to criticisms?
I do recall that line, yes. And it coincided with some improvements to the online system, which I accepted did make it somewhat easier for people to resolve their situation.
It didn't make it any more true that it didn't change how income was assessed or how debts were calculated.
No.
You received the email from Colleen Taylor, did you? Who was a departmental officer who explained very clearly how things had changed.
Yes, I did. At the time, again, in terms of my responsibilities, when I received that email, my immediate reaction was to identify the fact that the secretary had been copied in. I can recall putting a call through to the secretary's office. I think I spoke to her executive officer and I said, am I right in assuming that your office will deal with this? And I was given that assurance. So I allowed that process to continue. I think it's important to understand that in a hierarchical structure like that, you operate within defined roles. Now, had the Secretary's office not dealt with it, I would have dealt with it in much the same way as the Hank mailbox is dealt with. However, once I was assured the Secretary was dealing with it, that was really the end of my involvement.
The Hank mailbox was an email address established, I think, in response to a Triple J hack interview, or at least described for the first time on a Triple J hack interview where people could email that mailbox with complaints and the like.
The Hank mailbox had been in place for a number of years prior to that.
Right. And it was, well, perhaps if you could describe the purpose behind the Hank mailbox.
Certainly. Look, as I indicated, my role is to be a human face of the organisation, a senior human face in the organisation, who provides information, helps people navigate the system, listens and resolves issues. Particularly in a talkback radio environment, as you can appreciate, I can't discuss the personal circumstances of an individual. So I provide two options. One, I will normally say on air, look, if you stay on the line and provide your details to the producer, I'll have someone follow it up. And then at a more general level, I'll make the statement, look, if you're feeling lost in the system, this is not a line, this is not an email for general information, but if you're feeling lost in the system, you can write to me direct, and I provide them with that email address.
Was it you who dealt with all of the emails which landed in the Hank mailbox?
No, that would have been an impossible task.
Yes.
It was referred to a specialist team that is trained to deal with customers. Sorry, I should correct that. It was initially created within the communication division because it was recognised as being associated with media. And what that meant was we initially put in place a monitoring mechanism and then referred it to a specialist team that deals with customer complaints, who would then work with the customer, often make a phone call and help them resolve their situation.
So applying the concept of the Hank mailbox to the Colleen Taylor scenario, and if the secretary hadn't dealt with it, you would have dealt with it in much the same way as that.
In much the same way. I wouldn't have referred it to the Hank mailbox.
No.
I would have ensured that the business line appropriately dealt with it.
Which was what? Fobbed her off?
I'm sorry, I didn't hear that.
What was regarded as the appropriate way of dealing with Ms Taylor, fobbing her off? Because that's what happened.
Well, I'm sorry, that's not my understanding. My understanding was that the secretary actually ensured that a couple of people engaged with her to gain an understanding of what the issues were.
And did what about it?
I can't answer that. I don't know.
Thank you, Mr Jongen. I had no further.
I've got one more. Can we go to CTH 3748 0001 0007? This is one of the many documents you refer to in your statement, and what it is an ABC News 24 transcript. You were on ABC News in an afternoon in January. So if we can get that up. Or does it not follow if it's one of the documents referred to in that statement schedule that it will be available?
I think it will be available, and we're just identifying it.
January 2017, it was Mr Jongen.
So if I can assist, Commissioner, it should be available. It's not in the exhibit list though, so that might be a little delay in getting it brought up.
Okay, well, perhaps I can just put to you what I want to put and you can tell me about it. In that interview, you say a couple of times, we've sent 169,000 letters. So far, 8 out of 10 people that have responded have acknowledged that there is a debt and have put in place arrangements to repay that debt. That statement just looks wrong because you could hardly say that 8 out of 10 people had even responded, let alone acknowledged there'd been a debt. That the figure seems to be based on the fact that there were about 20% who'd had their debt set aside, and this is the remaining 80%, which would include people who hadn't even got the letter, people who'd got the letter and not responded, people who are still in arguments with the department. So there you are saying something that just looks wrong. How does that come about?
Well, as I indicated previously, I rely on expert advice from the business line, and in that situation, I would have asked for statistics to support any position that I was putting forward. They would have been the figures that were provided to me.
That 8 out of 10 people had acknowledged there was a debt and put in place arrangements to repay it. This is, sorry, my screen's a bit stuck for the moment. If we can come to the second page of that, and the second paragraph. And I can show you where you said it again.
Yes.
But
Look, in retrospect, it is quite possible that those statistics were extrapolated in that way. But at the time, to the best of my recollection, I had no reason to challenge that figure.
if I can get it taken over to the page 0010, and then the first entry that says Hank Jongen, and I'm interested in the bit that says, these arrangements between us and the tax office have been in place for many, many years. The methodology has not changed. What has changed is that we've ramped up the number of letters. Now, to be fair, literally speaking, data matching had been in place for a number of years. But isn't this a bit misleading, suggesting nothing to see here?
Look, I have to concede a loose form of words there. But I think it's also important to understand that in the hothouse atmosphere of doing a radio interview, sometimes you can revert to loose language. I have no recollection of this interview as such. But as you've indicated, there has been a relationship between the agency and the tax department in the past, and I think I may have clumsily been referring to that. And
Certainly would have given the impression that there was nothing to worry about. It was all as we'd been doing, wouldn't it?
Yes, it would. Yes.
Look, you were there was a reason they chose you as the persona, nice deep voice, comforting presence, sense of assurance. And so you were an important part of this, continuing this system. Did it not concern you that there evidently were all these problems and you were being used to sell it, a bit like a celebrity being used to flog a land development with perhaps not enough knowledge of what was behind it?
I think what I have to say is that in my role, I fervently believe that I have responsibilities to our customers, and I take that very seriously. I also seek to represent our staff in the best way possible, and I'm therefore, as I indicated to you before, I try and focus wherever I can on the actual customer experience and try and ensure that I maintain the trust of the people that I'm dealing with by myself examining the elements of the customer experience. I don't see myself as a salesman, quite frankly. I do care about the organisation. I care about our customers. And I've seen across the board the impossible situation that many of our customers find themselves in, not only in relation to Robodebt, but in their day-to-day ability to simply survive.
Well, you say you don't see yourself as a salesman. Do you think the department didn't see you as a salesman?
Well, that may be a perception held by some people, but I have to say that a lot of people that know me know that at my core, I am more than a simple salesman.
We'll leave it on that note, I think. Thanks, Mr. Jongen. Unless you've got anything else.
Just one question arising. What we saw, I think, from the first document I took you to, Mr. Jongen, was your extensive involvement in media in January. Did you take any steps to ensure for your own state of mind, that the statements you made, such as that, and statements made by the department along the lines of nothing's changed here, you have to trust that it's all okay, were in fact true?
Look, I have to say that the development of my talking points is a little, as you indicated earlier, there are three categories of the talking points. But generally, it's much more nuanced than me simply being faced with a set of talking points. As you can appreciate, I would have a discussion with the media officer about the way in which it was evolving. I would ask them to seek reassurance about the accuracy of information. And that would include the sorts of statistics that we've examined in this discussion. I would have asked, are these figures accurate?
All right. Thank you.
You want Mr Jongen excused? Oh, I'm sorry, Ms Hogan do it. Mr Glover, Mr Glover.
No questions. Thank you.
Thanks, Mr Glover.
Yes, thank you,
Yes,
Commissioner.
thanks, Mr Jongen. You're excused.
Commissioner, the last witness is Mr Bevan Hannan.
Thank you. Yeah. Mr Hannan, will you take an oath or an affirmation?
An oath, please, Commissioner.
All right, we'll have that administered.
Please place your right hand on the Bible. Your response is, I do. Do you swear by Almighty God that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Thanks, Mr Hannan. Take a seat. Mr Gregory.
Thank you, Commissioner. Can you tell the Commission your full name, please?
Bevan Hannan.
And your occupation?
I'm a public servant. I'm a acting General Manager of the Communications Division at Services Australia.
Mr Hannan, you were served with a final version of a notice to give evidence and produce a statement dated 23 December 2022.
Correct.
And you produced a statement in response dated 23 January 2023.
That's right.
Because you were served with a notice after the first two public hearings, I take it you had the opportunity to watch some of the evidence that was given in those public hearings.
Yeah, I'd suggest I binge watch those.
How did it make you feel?
The first 2 weeks?
Yes.
Quite upset.
And why is that?
Because from the evidence in those first two hearing blocks, it became apparent that people knew that aspects of the Robodebt scheme were unlawful. And we're into our 7th year talking about this now, talking about Robodebt, and there was an opportunity in January of 2017 to put a stop to it. And when it was a time to put the cards on the table, that didn't happen. And for the community who've been subject to the scheme, for our staff who've had to deliver that scheme, individual circumstances, and then continuing into refunds and class actions in our Royal Commission, and then the taxpayer, what all that has cost. As a public servant, I'm livid that there was an opportunity in January of 2017 to say there was a problem and it wasn't said. And yeah, it's a disgrace.
I should, of course, confirm with you that your statement is true and correct to the best of your knowledge and belief.
Yes, it is.
And the sentiment you've just expressed is touched on towards the end of your statement.
It is.
You had an integral role in the media process that related to the Robodebt scheme by virtue of your position at the time. And I know you're nodding, but it's being recorded, so you have to give a verbal
Yes.
response or an audible response. Is it fair to say that you were the immediate liaison in the department with Ms. Rachelle Miller, the media advisor for the minister?
While she was in that role, yes, for large parts of that. I've had a number of roles in communications during that period,
Yes.
but the Robodebt scheme was a core part of all of them, and certainly in all of them, certainly while Ms Miller was there, I was dealing with her very regularly, yes.
And that would be daily or multiple times a day, according to the circumstances of the media demand.
That's right.
And as you indicated, there was an opportunity in January 2017 for cards to be put on the table by the department about this. And that didn't happen. Can you explain how the media stories, which defended the legality and the fairness and the lack of any change to calculation of debts, were developed from your involvement at the time?
Yeah, so you're talking there about averaging. That wasn't on our radar at the time. Like, we honestly thought that averaging was something that was always done, and we were being reassured that was something that was fine. And it was certainly not on anyone's consideration that was unlawful. And so the way we communicated things through the media and broader communications was on the basis that was that certainly wasn't in question.
How were the media statements or the talking points, or however they might be described, developed for the Minister's office and for the public generally?
So we would have our media team would work with the relevant business area. There was a process that applied for the Robodebt scheme, that applied for everything across the agency. We had quite a regimented approach to how cleared media content was expected to be prepared and delivered and then shared with the Minister's office. And so,
I know you're about to go on to answer my question, but can I just pick up the point you've identified there, the regimented process? Who established that?
the process was established by the then Secretary, Catherine Campbell.
And it involved a clearance at a secretary level for a number of aspects of the media process?
Ms Campbell's clear expectation is that any cleared media content had to be approved by the responsible Deputy Secretary. So nothing that our team prepared went to a Minister's office without getting that level of approval.
You say that you were assured of content by the business area. And in the case of Robodebt, who was that?
There was a number of people involved in those early stages. I mean, ultimately, it was the Deputy Secretary, Melissa Golightly, who signed off on everything. But in those early days, there were a number of executive level staff who we would have consulted with and signed things off with. National manager level would have been Scott Britton. There was an acting national manager, Gary Clark. At the general manager level, Karen Harfield and Marcus Markovic, and another one, Craig Storen, and he was acting in those early stages for a period when Melissa was away at the deputy level. So they were the regular people we consulted with at that executive level before Melissa would sign off on it.
And in terms of drafting material for the Deputy Secretary's sign-off, the content was that averaging had always been used on that critical point.
Can you repeat that, please?
The content of the assertion that averaging had always been used by the department was generated by those persons you've identified in the business area.
Yeah, correct. If I could put that in context as well, like averaging wasn't the only thing that was being mentioned. It was one of the early things that was mentioned, but there was a good dozen things that people were shooting holes in it on and complaining about. So that was one of the aspects. But as for our knowledge and where we thought averaging stood in things, at a secretary level, and I refer to it in my statement, there were two key points which gave us overarching guidance on where the legality stood. The first was a more of a off-the-cuff email I got from Ms Campbell, where she was commenting on some media interview involving ACOS, and she indicated in that email that a point that the ACOS was making was quite valid in relation to automation, but we also have to be mindful that we have to ensure things remain lawful. Words to that effect. So for me, the secretary wouldn't have said that if she didn't think that she thought it was lawful, and her expectation that it was lawful. And the other one was from the Secretary of DSS, when we saw what was written into the Ombudsman, when the Ombudsman was brought on in January of 2017 to help improve the customer experience and make sure that we were doing things in a way that were fair and user-friendly. The letter which went from DSS to the DSS Secretary to the Ombudsman was that the legislation was squared away. So from our point of view, you've got two of the highest level people saying that was our guidance. It wasn't questioned otherwise. It wasn't until 2019 that it became absolutely apparent that it was unlawful.
What role, if any, did the Chief Legal Counsel, Ms Musolino, have in the work that you did in the media sphere in early 2017?
If the matter required a legal review or had an aspect where legality was a part of the response, or, for example, if it involved releasing customer information, for example, they're the types of scenarios where Ms Musolino may have been involved in clearing or reviewing content.
Did you ever speak with her about the scheme and her views of the scheme?
Yes, I did, but whether it was lawful or not, I can't recall.
That is, whether the topic of lawfulness was raised.
Yeah.
In your statement, you identify some features which, on reflection, you think created an impetus for a poorly developed scheme, which was unlawful, to gain traction and be implemented for so many years. One of those was an election promise or election commitment in mid-2016. Can you explain why you consider that to be a factor?
Because in the lead up to that election, and it was a long election, we had about a 10 or 11-week caretaker period. Prior to that, there'd already been announcements, a budget announcement, then a MyEFO announcement, which was identifying welfare compliance projects that were going to realise savings for the government. Then, a few days out from the election, the costing document comes from the coalition, and it refers to how it was going to make up for the $1.2 billion in extra expenses that they'd promised in the election campaign since the May budget. Since the budget. And that costing document made it clear that was going to be offset by another round of welfare compliance measures. And so that was over $2 billion in that costing document. So already there was a big expectation that the agency's compliance area was going to be generating a lot of savings through these programs, but then the pressure was heaped further on with that policy announcement in the lead up to that election in 2016.
And as I understand your answer and what you've referred to in your statement, you're identifying that within a couple of days of the election, that is the general polling day, announcements were made which had a direct impact on the department in terms of its need to find savings.
Correct, and the expectation was that these savings were going to help chase down the bottom line, the surplus for the government. You know, like it was not unlike a tab, from my point of view. Like it was retrospective. A tab doesn't make money from high rollers. It makes money from the little guy, the little bets, the cumulative total of the little guy. And this was not unlike that, in that it was a scheme where they identified a big pool of people who they could get smaller amounts of, but it was together, it was going to add up to a lot of money, and it was a big pool of people to skim from.
You also refer in your statement to the approach taken by ministers in the media, which led to, as it were, in fact, counterintuitively drawing criticism on the scheme. What are you referring to there?
Which you got a paragraph you can point me to there, or?
Well, if you go to paragraph 183 in your statement.
Oh, yes.
You describe the minister's bullish activity. Can you elaborate on that, please?
So the backstory to that is when we became aware the extent of what the activity was occurring already in relation to these initiation letters, we found out that we prepared a media release for the minister to announce a milestone, not in relation to the online compliance program, but in relation to the cumulative measures that had been in action to recoup savings from the government from those previous budget announcements. And there was a milestone figure coming, and the business area was going to provide that number to the minister's office. They didn't do it in a timely way, and the minister's office wanted to find another story instead to talk about the efforts and progress of these compliance activities. So a phone call was made to me to explain that they need to come up with another idea. And that idea was the fact that they've been doing these online compliance activities where they were suddenly doing the same amount as you do in a year in a week. And that was the first I knew that it actually had been occurring. I thought it was a minor miracle that it already hadn't become an issue, because it had been going for months. And normally in service delivery, if things are going wrong, it doesn't take long to get into the media. And I was highly surprised that we probably had 200,000 letters had been initiated by that time, and there's been nothing. There'd been no political reaction, there'd been nothing in the media, and I was highly surprised. Knowing it was getting close to Christmas as well, it was very clear to me that it was only a matter of time before we did get a complaint, and the government hadn't explained what we're doing, and our agency hadn't explained what we're doing. And I felt I agreed with the approach to me that we should talk about it instead of what they were planning to do, and be transparent and explain to the community what it was that this activity was, and that it was underway and what it meant. The Minister's office agreed to run with it, and they did the announcement in early December. But from my point of view, there was still a shot to be able to have clear air and explain the reasons without that resulting in being a reactive situation where a complaint would have framed the issue and they would have been on the back foot trying to explain what they were doing and perhaps being accused of not being transparent. But that was all contingent on, is everything working? And we were being assured everything was working. We heard there were irritations in the network that we should ask questions about, and we did ask those questions, and we were being assured that everything is working as it should. So then it was a case, well, he's got one shot to get this on the record, and to have some clear air, and if everything's working as they say it is, it might turn out okay. But it didn't transpire that way, and you're referring to the bullish media comments, it was handled by the minister in a very bullish way, and the comments that appeared on A Current Affair on the Monday, the 6th of December, Monday, 5th of December, I think it was, sorry. There was a grab used there at the start of the segment where he referred to tracking people down and also perhaps ending up with prison sentences. Had nothing to do with compliance. It conflated welfare fraud with compliance activities. The rest of the story had nothing to do with putting people in jail, but that grab seemed to galvanise everyone. And so suddenly, instead of being a story which would explain what we're doing, it put a big target on things, and the program and the minister became the hunted.
I take it that wasn't diminished in any way by Minister Porter's defence of the program while Minister Tudge was on leave over the Christmas break?
Well, Minister Tudge as well tried to, like the office was very, very keen to try and put it, because it built over the month. It built over December, and in the back half of December it really built. Before Minister Tudge went on holidays, he did go on Triple J because that was one of the outlets that was giving it a lot of attention. They were getting a lot of hits on their website about it and comments about it. That was part of the galvanising. The people who were affected by this were, young professionals, digital natives, and so they can consume all their news online. And The Guardian had been following it during the month. Triple J was another one that came into play, and then you had community activism like Not My Debt getting marshalling as well. And so by the end of the month, there was people were really discussing it and questioning what was happening. The office was starting to see that and wanted to put it to bed before Christmas, and I think they thought by Minister Tudge doing this interview, it just might well deal with it, but clearly not. And so Minister Porter was left with the baton over that period where Minister Tudge was away, but really it was a stopgap, and it didn't stop the community reaction.
It's 5 o'clock. Can you finish Mr Hannan's evidence in the next half hour or not?
Yes, I can.
Okay.
Mr Hannan, things built, as you say, through January 2017. How did the media team at DHS deal with it?
I refer in my statement, it was like sandbagging. It was the biggest issue the agency had dealt with on a reactive basis, and it was quite intense. There was a small team that was on call between Christmas and New Year when it broke, and when it really burst into the mainstream, and then it kept going into January. And I think I refer in my statement, one of the executive briefings that we had in those early days. It was passed on from the Prime Minister's office that they were happy with our sandbagging because they thought that the issue would move on, and while it was running, that it was keeping another issue off the front pages and out of the spotlight, which was another 1st of January change that we implemented, a policy change in relation to aged pensioners, and they were sensitive about that and thought that Robodebt was keeping that off out of the media spotlight, and that it would move on in time. But it was very clear that this was here to stay.
Your view was that the age pension announcement or policy change implemented from 1 January 2017 could be dealt with in a positive way rather than avoiding it?
How the two matters were handled were chalk and cheese. You had one that was handled smoothly and another one that imploded. And the difference with the age pension, to give you an idea of numbers you're talking about, there were about 500,000 age pensioners affected by that assets test change, and some of those were going to get an increase, some were going to get a lower payment, and some were going to go off their part pension. There were about 3.5 million age pensioners not affected, but about 500,000 affected. We spent months with a an aligned communication plan with the business area to ensure we had information in the letters going to people to explain it that linked to information and resources. Like on our website, we had a rate estimator which people could interact with. I think we had 600,000 people alone interact with that. And there was a range of other customer communication materials and channels that we used, including the mainstream media, where there was at least 1,000 broadcast media items where we were educating the community about the change. So when it happened, people were clear about it, and it wasn't an issue. And the reason that it wasn't an issue wasn't Robodebt, it was because they'd been communicated to. And if it had been a problem, we would have heard about it on AM radio regardless, and there was no noise on AM radio, and AM radio wasn't covering Robodebt. So we knew that the age pension had been dealt with properly, and that Robodebt had not.
You say that in your statement that you now know from what's happened over the last few years, and indeed in this commission, that there was a secret about the existence of knowledge that the scheme was unlawful. Did you ever talk to Melissa Golightly at all in any of these communications between you as in the media role and her as the Deputy Secretary about the information that was being communicated through the business area in the face of the sustained external criticisms?
Yeah, look, there was some reticence to accept that there was a problem to start with. And when it had broke open between Christmas and New Year, it was clear to me that we'd have to do something. We couldn't be, from a communications point of view, couldn't be on the sidelines anymore. A decision was made at some point to do the communication through a letter. And not such in theory, okay, when you're talking about, I think we'd had 200,000 by that stage, thereabouts, and there's going to be obviously adding to that. So it wasn't a huge number in our context, but it was a number that was going to build. She didn't want to believe what was in the press. And she didn't want to believe, and I know what fueled that, because some of the media reports, even in those early stages, it was very clear they weren't Robodebts. And so she wanted the system to be working, but her consistent message was, we've got to keep correcting the record. The system's working okay, and these case studies, we need to look into them to make sure that they're valid, because to me, we need the evidence. And so she was on that pretty much between the 27th of December 2016 and up to about the 2nd, when she asked for formal media advice. She'd formed the view that it was some sort of campaign, and she doubted what people were saying, and she really wanted the system to be working. Now, there clearly was a campaign, but there was a bit more substance to the campaign, and it took her a while to come to the realisation that there were some problems we had to fix.
I take it lawfulness never came up in conversations with her?
Well, they did, and she asked for the advice. In the end, she asked for the advice on the 2nd of January, which was a Monday public holiday after New Year, before we were coming back everyone was back at work, and I'd made the decision over that weekend we needed a plan, and that I'd have one ready for that next day. And coincidentally, she asked for one on that Monday night, so we had it ready, and I put it forward. And it was very clear in that advice that I provided on the 3rd of January that customer experience was at the centre of this, and we needed to get it right. We needed to review everything from letters to the contact channels. That this was not something that could be denied anymore.
But I think the question was whether lawfulness ever came up with her.
Not at that early stage. Like at that early stage, Commissioner, people were talking about the fairness of averaging has been one of the good dozen issues they were talking about. But I don't think anyone at that stage, there might have been a journalist perhaps suggested it, but it was the fairness that was being questioned at that time about averaging more so than the legality.
If I could have Exhibit 4595 brought up. Mr. Hannan, this is your media strategy, 3 January 2017. I see there's a folder in front of you. The hard copy is behind tab 48.
Thank you.
CTH.3098.0009.8782 for Exhibit 4595. Thank you. This is the strategy you describe, or just described, tab 48.
Thank you. Got it. That's the one.
That's the one that you developed because of the situation you observed unfolding. As I read that, I don't see any reference to the question of legality in here. And is that because you didn't perceive that that was a criticism at that point?
Yeah, as I just said before, it was the fairness of averaging, which was being brought up, but the legality wasn't so much a thing that was being brought up.
Right. When Ms. Golightly sought advice, I take it that was on your evidence, her acceptance that there needed to be a strategy to deal with the developing situation.
And this was a precursor to. I filed this advice on the Tuesday the 3rd, and by the Friday we'd had a follow-up proper communication plan fleshed out, and it was with the acting secretary and deputies by that Sunday that we needed to crack on with to try and help the community understand what they had to do and give them that customer information that had been lacking.
You described there, I think this is invaluable content for journalists during the silly season when story angles are lean. You're talking about the downtime between Christmas and mid to late January.
Yeah, correct. And see, part of Miss Golightly's frustration was these case studies that had been appearing in the media, and they were coming straight off socials. That's where people were getting them from. So for the journalists in that time looking for stories, they were all there. The conversation was happening in public, and they were getting some really good leads on people who were aggrieved at the reviews they were being subject to.
As you set out in your statement, the media issues or crisis continued throughout January. What do you recall was the point at which it started to dissipate or go away?
The peak. There were a couple of peaks, but there was certainly a January peak where it was very intense, and then. I think I described it in my statement, like it hit like a tornado or a cyclone, and then the agency was just flooded for the next 6 months from the resulting crisis, from all of the things that happened stemming from the media, from everything from FOI requests to the inquiries that happened, the ombudsman, like the attention on it, it just it paralysed the place for a good 6 months. The media attention probably, it wasn't as high as January again, but it continued and probably didn't properly wane until after the first Senate inquiry report was handed down mid-year.
What degree of involvement, to your recollection, did Ms Campbell have in the process relating to media and responses?
It depended on the situation. Probably had more involvement in January when we're at our peak than anything else, but that's also because you had Minister Tudge looking carefully at it, and Minister Porter was as well in that month, because in January is when they had to make some decisions. You know, like is this is this something that we can fix and move on, or what are we going to do with it? And clearly the decision was made, we'll make some refinements, and by the end of the month they committed to the dollars that the program was going to recoup for the government. She was involved in particular media inquiries, and there were certain things where she personally wanted to review before they went out. It wasn't all of them, but it was depending on whether the minister had a certain interest or whether she personally had a certain interest. But there was probably a handful of occasions where she requested to clear and review the final before it went out. And normally she would leave that to her deputies to do, but there were occasions where she would also want to review, and that probably happened, a handful of times during that January.
You say in your statement that come January 2017, there was the chance for frank and fearless advice from those in the public service who knew that at that point there was no lawful basis for the system or the scheme to say so. And you've identified the advantages of that there wouldn't have been 6 years of dispute about it, people wouldn't have been impacted, the customers, the public funds, the taxpayer waste which has occurred as a result. All of that suggests it would have been an easy thing to do, but plainly it wasn't. And based on your experience as a member of the APS, what are the features that you identify that weigh against a cards on the table approach in January 2017, as you've described?
There was no reason not to bring it forward. Like, how many other eyes did you want to have on it? You had both ministers looking at it. You had an ombudsman involved. It was, one of the big issues in Australia over that summer. There was clear problems with the system. So many of us were wishing it would stop. And we had confidence that because it was being looked at thoroughly, that if there was a problem and there was something of that magnitude, ministers were reviewing letters and the online portal and features on the portal as part of that refinement process. That's the level of, they had deep engagement with what was being done to deal with the situation and make any fixes. If they're prepared to look at features on online portals, I'm sure they could have found some time to look at advice that it was unlawful.
What of the reputational cost at that point to a department that admitted that the scheme was unlawful, even though the government had assigned some significant savings to the measure only 6 months earlier?
There would have been some difficult discussions, clearly, and reactions to deal with, but I don't think, certainly I mentioned the email from Ms Campbell, who actually mentioned unsolicited lawfulness. If she knew that it was unlawful, there is no way, in my view, she would have let that proceed in the way that it was going. She would have had to have done something about it.
So where do you see, based on what you now know and your experience in the APS, the issue, why it didn't happen as you now expect it ought to have?
I'm confounded. I just don't know. I just don't know how, if someone knew that an ombudsman was looking into it, and I put my hand up, we use that ombudsman's report to defend the system for the next couple of years. That was our go-to, the ombudsman's report. Like, the ombudsman was looking at it. I said it up front, that's when all cards had to go on the table. Like, it was an abrogation of responsibility that was not mentioned at that time. It had to be. Like, it's one thing to have a poor execution of a program which was under pressure to deliver, and it didn't go right. There's one thing to get it wrong, but there was a second chance. There was a second chance to get it right, and I cannot understand. I don't have words. I don't have words as to why, if you had that knowledge, that you would not stump up with that.
Just briefly, there was a part of the defence of the scheme and the case studies that were involved, sorry, not case studies, part of the defence of the scheme was the release of personal information to correct what was said to be inaccuracies in the media. And in some circumstances, there were reports of suicides related to the scheme or to debt letters. Do you recall preparing briefs for the Minister's office or having briefs prepared for transmission to the Minister's office in respect of people who were said to have suicided as a result of debt letters?
There was certainly media inquiries in relation to that. There was probably one in 2017 in the early stages.
Was that Mr. Reece Corso?
Correct, yeah.
Yes.
Yep, that occurred in February of 2017. I was actually on leave in February of 2017, so that response I wasn't involved in. My team was involved in that while I was away, but I wasn't involved in that personally.
And there may have been a later one relating to Mr. Madgwick.
Yes, in 2019, yes.
2019.
Yeah. And there was also in 2019 in relation to suicides too, there was where that discussion particularly ramped up was on the back of a Senate, one of the Senate inquiry questions where one of the senators had asked how many people had died while during the program, and that number came back. It was in the vicinity of 2,000, I think it was. And there was a lot of media reporting around that reported that as being suicides when it was people who had died. And that was a real catalyst as well for a lot of discussion around that.
Right. I have no further questions.
Mr. Glover?
No, nothing arising. Thank you, Commissioner.
You haven't asked for any leave. Mr. Goa, I take it you've got nothing? All right, thank you. Do you want Mr. Hannan excused?
Yes, please, Commissioner.
Thanks, Mr. Hannan. You're excused.
Thank you.
We'll adjourn until 10.
Oh, Commissioner, might I just raise one matter quickly? You might recall on Tuesday last week with the evidence of Ms. Martin, I sought a non-publication direction over her oral evidence. I just thought I would update the Commission because it was only meant to be temporary.
Yes.
Redactions have been agreed and they're very minor. And her statement, her evidence has now been published on the Royal Commission's website. And if you considered it necessary, you could vary your non-publication direction and we can prepare a form of words if that would assist.
All right, thanks. If you do that. Thank you. We'll adjourn.
All rise. The Commission stands adjourned until 10 a.m. tomorrow morning.